Welcome to Crestview Community TV's Court TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today we're watching a miscellaneous court date / VOP court date. You're going to see, by VOP we mean violation of probation, and you're going to see a lot of people this morning who are, a lot of them are going to be incarcerated because they violated their probation. When you violate your probation, you're not entitled to a bond. Doesn't mean you can't get one, it means it's harder to get one. On a new law violation, most people are entitled to a bond, absent some major circumstances. When you violate that probation, though, you're not entitled to a bond, but you can get one. But that leads this court date to having a lot more inmates. Now, when you're called to the podium, a couple things you can do. You can enter a plea to your VOP and say, yes, I did it, I violated my probation. And you can get sentenced. You can ask for a continuance. Let's set this down the road, maybe try to work out some details, maybe try to work out a deal. Or you can ask for a contested VOP hearing, which will be set at a later date in one of the afternoons of this miscellaneous date. Now, VOP hearings are very hard to win. It's a different standard of proof. We don't see a lot of them because it's rather easy for the state to prove if you violated your probation or not. So you're not going to see a lot of contested VOP hearings. Now, in addition to the violations of probation in the mornings, you're going to see some other smaller, shorter hearings, things like bond hearings, or things that don't take a lot of time, normally 15 minutes or less on these morning hearings. Anything longer than that is going to be set to the afternoon.
For today, but if there is any type of capias, I would ask that it be withdrawn.
Objection.
All right, I'll withdraw it.
And we've reached an agreement in this matter, if I may approach.
Very good.
Misdemeanors, Your Honor.
All right, you are Miguel Robles, is that right, sir? Okay, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God. This is 22 CF 1213. You want to enter a no contest plea to a lesser included offense of misdemeanor of possession of under 20 grams of marijuana and another misdemeanor possession of paraphernalia. Is that correct, sir? Okay. Did you read and sign this plea and sentencing agreement form, which explains your rights? You aware of the rights you're waiving by entering this plea? Has anyone forced you or threatened you to enter this plea? Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today? Are you happy with the work Ms. Rivers has done for you on your case? Court finds the plea is freely and voluntarily entered. Court accepts it. You are sentenced. Is it concurrent?
Yes, Your Honor. It's 11 months, 29 days of probation. He does now reside, just recently moved to the state of New Jersey. His stepfather is here, and we're asking if he can do his initial visit in person, but then mail in since he is in the state of New Jersey.
State does not object.
All right. The court sentenced you to 11 months, 29 days probation, concurrent, have a substance abuse and mental health evaluation and complete any recommended treatment. You're not to consume any alcohol or drugs or take, unless there's prescribed medication. $270 court cost, $50 cost of prosecution, $100 PD fee, and waive cost of supervision. Adjudication is withheld. And after initial check-in, you can transfer your probation to New Jersey. Okay?
And also part of the plea, Your Honor, is because he will be out of state. If there is a violation of probation, the witnesses can appear via Zoom with the presence of a notary.
All right. Court orders that too. Okay? All right. Thank you, sir.
Thank you.
Next.
Morning, Your Honor.
Morning.
Your Honor, I have 2 inmates on the docket. I'll step aside.
All right.
Morning, Your Honor.
Good morning.
Brittany Merrifield on behalf of DeAndre Asberry and 23 CF 1060. I believe he's on page 2 of your docket, Judge.
DeAndre Asberry. Okay.
Yes, Your Honor. Judge, Mr. Asberry is before the court on our request for bond reduction. He's been incarcerated since May the 9th. His original bond was set at count 1, $100,000 cash or professional, and count 2, $25,000 cash or professional. The amount of bond based on Mr. Asberry's financial means and the means of his family, it's tantamount to no bond. He was a stay-at-home parent at the time of the allegations, so he is not employed and doesn't have any means of income to afford the bond as set. His parents are present in the courtroom today. They traveled from Virginia to assist their son, and they would be responsible for any bond. His father is former law enforcement. His mother is a stay-at-home. She works full-time from home, and both would ensure that he abides by all court orders and returns when required to do so. Consistent with the original recommendation of mental health pretrial services, they wanted him to access psychiatric treatment. His grandmother is a court-certified counselor for Virginia court system. She has already established a therapeutic program for him that he would be attending. It would be the intention that he returns home to stay with the family while the charges are pending. There's also a temporary injunction that is still in place in effect that prevents him from being able to be near the listed victim's residence or contact the immediate family. I did speak with Mental Health Pretrial Services. I noticed on his first appearance paperwork that they had recommended that he have some sort of GPS, also with house arrest sanctions. According to Mental Health Pretrial Services, it would be easier for them for supervision purposes to have him on a GPS and not impose house arrest sanctions if he's going to reside out of state. What they did inform me is that they can place a zone around the listed victim's home, so that would prevent him from returning to Florida or to be anywhere near the listed victim. He does not have any criminal convictions. He's never failed to appear. So we would request a reduction to a reasonable amount.
State, sir.
Judge, we believe the bonds are appropriate as such. The defendant in this case is accused of battery and suffocating his 2-year-old. The mother saw what was happening on Nest camera and called law enforcement. She stated she saw him grab the child by his legs, slam him down on the bed multiple times, and then put both of his hands over the child's face where he couldn't breathe 3 times before dragging him to the other side of the bed. He said his son wouldn't stop crying and expected him to be a boy. That child's medical injuries include petechia around the eyes, neck, and ears, consistent with oxygen deprivation, loss of consciousness. He also had bruising and abrasion to his face and body, and a non-displaced buccal fracture, basically broken left arm. As charged, he scores 63 months Department of Corrections with a max of 35 years. This is not the first time there has been domestic issues or violence. He was discharged from the Navy based on a battery on his wife in which he drug her up the stairs and kicked her in the stomach in 2022. So based on the totality of the circumstances, we believe the bond is appropriate as set. However, if the court is inclined to reduce the bonds, we do have concerns, given he has no ties to this area, including employment. He's been ordered not to have any contact with the immediate family that is here. So we would ask to include GPS and some sort of in-person check-in. Could you reduce the bonds?
When is he set for trial?
It's a brand-new case, Judge. I believe that he has his first pretrial on August the 28th, and I would like to address one of the contentions of the prior history. It's my understanding, based on pretrial's investigation, that that case was dropped. I don't have any details about the case being dropped. And also, this is not, I understand his ties to the community are a little attenuated, but he does have very diligent parents. They hired my services. They have stayed in constant communication, and we have, strong professional parents that also have a firm footing in the therapeutic program in Virginia, and a former law enforcement for a father. So I would rely on the parents' diligence to help bring him back to court when required to do so. We would also agree with a GPS, ask that it be at $1 a day. But Judge, I think the financial burden of traveling back and forth to Virginia for check-ins, we would ask the court to minimize that every few months while we work this case.
We would have no objection to local check-in, could you coordinate? But I would just ask to be some sort of an in-person check-in, whether it be in Virginia or here.
And given that his grandmother is a counselor for the Virginia court system, we may be able to coordinate that with the Virginia court system.
So, his family's all in Virginia,
Yes, sir.
and his father's law enforcement?
His father is former law enforcement. He's in the courtroom today, and his mother works 100% of her time from home. So he would have somebody at the home for the entire duration.
What's his current bond?
His current bond is, count 1 is $100,000 cash or professional, and count 2 is $25,000 cash or professional.
Well, I mean, what are you asking for?
We would ask for count 1 to be reduced to $25,000 cash or professional, and count 2 to be reduced to $5,000 cash or professional.
The state wants GPS monitor, is that what you're saying?
Yes, Judge, we ask for GPS, the pre-trials, the no contact with the victim or victim's immediate family, cooperate with DCF, DCFS. And some sort of an in-person check-in, be it here monthly.
His family's here, is that right?
They are, Judge.
You're his father, is that correct? Correct. And mom? Has the victim, as a child, has the mother of the child been consulted with us?
Judge, we reached out to her, however, we do believe that she has gotten a new phone number based on this case. She's applied for an injunction.
There is an injunction in place, Judge. The temporary has been extended.
I'll grant it, but with the state's additional conditions, with a monitor and all that, and prepare me an order, stipulated order, listing those additional conditions, and I'll make it $25,000 cash professional account 1 and $5,000 cash professional account 2, with those additional check-ins and GPS monitor and pretrial services, supervision, all the things that are required.
Thank you, Judge. And would that be GPS at $1 a day?
Yeah.
Thank you, Your Honor.
I'll make sure he shows up. You'll lose that money. Bondsman will come get him. He won't get away. All right, thank you. Next.
Thank you, Judge.
Next
Judge.
case.
The next case I have is Wyatt Mann and 22 CF 3068. You got to come stand here.
Where's he at? On the dock? 5? Okay. All right.
And Judge, just for the record, there was a previous attorney that was assigned to 23 CF 824 that had filed a motion to reduce bond. We are not adopting that motion. We are simply here today on our motion to reinstate bond on 22 CF 3068. So Mr. Mann's been incarcerated since April the 9th. His bond was revoked based on a new arrest on April the 9th. That's 23 CF 824. He is a resident of Crestview for about 2 years. Prior to the offenses, he was a general manager at a dealership, had what he believed to be a strong marriage, happily caring for 4 children. He has since been terminated from his employment and forced to move out of the family home. He has no financial means at this time, but he does have a prospect of employment if he were able to reinstate his bond, and his family would be providing any monetary compensation for a reasonable bond. He doesn't have a lengthy history. He's not a flight risk and hasn't failed to appear. There's no indication that he would fail to appear when required to do so. The decline of the relationship that he had with his wife prompted the new arrest in 23 CF 824. And Mr. Mann believed that he had, a happy, situated home life. It did result in heightened emotions. Quite frankly, it broke him. His reactions are not something that he is proud of, and he has certainly had some time to think about that. He was originally placed on mental health pretrial services, and he has expressed concern as of late, based on some high dosages of medication that he was prescribed, that he would like to get some local help. He would like to have mental health pretrial services assist him in a therapeutic program. There are court restrictions that would be the least restrictive, that would protect the listed victim, that would protect the community and safety of the community. Imposing a GPS or house arrest style conditions or sanctions would certainly ensure the safety and avoid any other issues while still allowing Mr. Mann to get the help that he needs and gainful employment. Even if the court reinstates bond in this case, the bond in 23 CF 824 is substantial at $100,000 combined. So we would request that this court reinstate the bond, place him on a GPS monitor, and allow him to get the treatment.
Your Honor, if I may give the court a little background first, and then the victim is present here today. She would like to give her input as well.
Okay.
So while this defendant was originally out, he was first arrested on a misdemeanor domestic violence battery. So what I'm going to talk to you about, Judge, is 3 cases. They're all domestic related. 2 of them are felonies before us today. They're all with the same victim. So he was out on bond to a domestic violence battery to which he admitted to against his wife. He was put on pretrial services in November, including no contact with the victim, not to be within 500 feet, and not return to the shared residence, except for the one time to retrieve belongings. So once he was out on bond for that DV battery, 2 weeks after being given that no contact order, despite the fact he wasn't supposed to be 500 feet from the house or have contact with the victim, while out on bond, he was arrested for tampering with the victim by depriving means of communication, domestic violence battery, and willful violation of pretrial release. Those charges arose when the defendant pushed the victim several times, hit her with a belt 2 times, and told the victim, quote, "If you call the cops again, I'll blow your head off." While the victim was attempting to call 911, the defendant grabbed her phone, threw it to the ground, and shattered it. And this was done in front of, while children were in the house, and one child witnessed it and told law enforcement. So that is the case that the bond is revoked on. Then, after the defendant's arrest on that case, a risk protection order was granted due to the fact the defendant did own firearms, because it was determined by the court that he was a risk to himself and others due to mental health concerns. So now he was released on that felony case. So now he was out on bond for the DV misdemeanor battery and the felony case, again on pretrial services, with no contact with the victim in place. But the defendant, he's called the victim from the jail approximately 12 to 17 times, violating the no contact order many times. Ultimately, during that time period, the victim did write a statement wishing to drop the misdemeanor battery charge. So the misdemeanor battery charge at that time was dismissed. So he was still out on the felony with the no contact order, to which he acknowledged in the jail calls. So while he's out on the felony pretrial release, 4 months later, he was arrested for the second felony case that's before the court because he tried to ram the victim's car, tried to run her off the road. The victim called law enforcement. Law enforcement actually intercepted the defendant on the roadway, which started a 113-mile-an-hour chase down 85, going approximately 2.5 miles at a high-speed chase until law enforcement had to terminate their pursuit because of the danger to law enforcement and to the other travelers on the roadway. Shortly after the defendant fled from law enforcement, he ditched the car. He texted the defendant he texted the victim 49 times right after the high-speed chase, saying things, taunting the victim, such as, quote, "I always win," and, quote, "Thanks for stealing my car, LOL," and he, in a laughing manner. 30 minutes after those text messages were sent after the high-speed chase, the defendant made a report to law enforcement that his wife had stolen his vehicle. So once that was determined that the wife had not stolen his vehicle, he was trying to blame the high-speed pursuit on the victim, I guess, despite the fact that law enforcement positively identified the defendant in the vehicle during the chase, as well as the victim and an independent witness.
I think I'm going to leave the bond the way it is at this time.
Okay, may I see if the victim still wants to make a statement? The bonds are going to not be altered, so do you still want to speak, or are you good? Okay.
All right, thank you.
Thank you, Your Honor. And Judge, I'll submit written orders for both cases.
All right,
That's all I
thank
have
you.
today.
Thank you.
Thank you.
All right, Mr. Stewart.
Morning again, Your Honor. Your Honor, my first client before the court here today is Mr. Harvard. Judge, this is 22 CF 1810. Your Honor, Mr. Harvard is present before the court. We were before the number 11 on my docket.
Okay. All right.
Your Honor, we're before the court with regards to the status of this case. We set it on today in anticipation, hopefully, to bring this case in for a landing and resolve it. We do need to continue this case to the 26th if we can, and we are in substantive negotiations with the state where we're close to resolving this case. Anticipate moving it up once we nail down all the specifics.
State.
No objection.
All right, June 26th. Thank you.
And Judge, if I can.
Okay.
Who deputy? We got the deputy. In the abundant, well, I'm going to move it up once we get it nailed down.
Oh,
Because it was the.
here's what happened. Mr. Stewart muted. Okay, that's what happened. Okay, all right, thank you, thank you. You confused the court reporters, Mr. Stewart. That's what
With the
they were
mute button.
saying. We can barely hear, they thought it was me, but it was you apparently talking, so.
Yes, Your Honor.
Okay, you muted your mic, and the court reporters were going nuts, thinking it was me, not, they couldn't hear me very well, but, okay. We got
Yes, Your
Mr. Harvard set for June 26th?
Yes, Your Honor.
Okay, thank you.
Your Honor, my next client is Mr. Robert Lundy, Judge. Believe Mr. Lundy is number 12 on the docket.
All right,
And for the record, Judge, this is 20 CF 800, 20 CF 2291, 21 CF 703, Judge. The state and I have an agreement that they are going to dismiss the violation of probation, and Mr. Lundy will be reinstated on probation to complete all of his original requirements. Judge, I do have an order to that effect, if I may approach.
That's correct, Your Honor. The only violation was a misdemeanor that was dismissed.
all right, so the state's going to dismiss the violation of probation and reinstate probation, and on the original terms, and complete all original terms. Do I need to take some type of testimony on this?
No,
Just
Your
Your
Honor.
Honor, you
just
can
a-
just
okay.
announce that the VOP is dismissed and he's reinstated to probation.
All right, you're reinstated to probation. Get it completed so you don't have to go through this, okay?
Yes, sir.
Thank you.
Mr. Lundy. Your Honor, that's all I have for the court. May I be excused?
Yes.
Thank you, Judge.
Who we got next?
Just need one moment, Your Honor. Just
All right.
Leah Glisson on behalf of Paul Gillespie.
All right, this is 23 CF 896, State versus Marion Velazquez. Velazquez, is that right? I've received various motions. The state wants to modify conditions of bond and reset the bond hearing because they have, I guess, a special prosecutor. And the defense, as my understanding, has filed some motions objecting to a continuance and wanting to modify bond conditions also. Is that correct?
Well,
or-
it's just a generalized objection. I don't think we filed a motion
Oh, you
necessarily.
didn't? Okay. Well,
We
all
said
right,
file a
so-
motion to set bond.
you
or
wanted to,
respond.
all right, well, go ahead.
Judge,
Are we arguing for the bond motion or the continuance?
Continuance
Okay.
first. Yeah.
state's burden.
Your Honor, Mr. Gillespie, he is the white-collar special prosecutor for our circuit. He is asking for a continuance. I don't believe the matter was coordinated with him. He had a pre-planned flight out of state today, so he's asking that, based on a lack of communication and coordinating with him, that we continue this case. He said it's going to definitely be longer than
Hang on
15
one second.
minutes.
Rachel? All right, go ahead.
He said it's definitely going to be longer than a 15-minute hearing based on the testimony that's going to be taken. There is a Homeland Security agent that needs to testify, and also that a continuance will not prejudice this defendant, Your Honor, because I have been provided paperwork that he does have an ICE hold on him, and I can provide the court with that was provided to me. So continuing this matter to June 8th would not prejudice the defendant because he's on an ICE hold anyways, and I can approach. I've showed defense counsel this.
Mr. LaPella?
First of all, Your Honor, in 20 years of practice, I've never coordinated with the state on a bond hearing. I don't think that that's a practice that we should be in the we should be doing as advocates, nor do I think the court should endorse such a practice or a procedure that the state would want to have another impediment to a bond hearing. The state is required to be in attendance if there's a, they have prosecutors, they could cover it, whatever they want to do, but we don't coordinate for bond hearings. I've never done that in my entire career. Second of all, my client's in jail, he's prejudiced. He doesn't have a bond that he can make, that he can afford. The determination of an ICE hold is to be determined. It's a foreseeable issue, but a lot of times we have clients, they go to ICE and ICE says, we don't want to hold you anymore, and they let them out. So that's not a valid basis for prejudice, nor is the lack of
He
coordination.
does have
with
a
the
bond, correct?
He has a
Sure.
bond, but it's.
There is an ICE hold. The state is asking for a delay of a week or so to June 8th. They got apparently a special prosecutor. Apparently, there's numerous alleged victims in this case. So the the court is going to grant the motion for continuance to June 8th.
I had one more point I have to make, Your Honor, for the record.
Okay, go
And
ahead.
I didn't know the court was going to make a ruling on the continuance. Judge, I read the police report. I don't know if the court's read the arrest report in this case. Okay, just very briefly.
We don't get the arrest report.
Okay, well, there's an arrest report in this case. And my client was stopped by FHP. He was a passenger in the car. They did a canine sniff. They did the sniff, they did a search, they found drugs in the car, they found some contraband that might be used for fraud. Okay? After that, they didn't charge my client with drug possession. They charged him with fraud and a bunch of things where he actually allegedly committed fraud on people. But there's no evidence in anything in the police report. There's no factual discussion at all about his involvement in any fraud.
I'll be
He's
happy
guilty
to
by
hear I'll be
association.
happy to hear all this at the June 8th hearing. Thank you.
All right, Judge. I would ask the state to bring forth more evidence if they plan on presenting.
The state knows what they need to do.
Your Honor, it's my understanding that discovery will be provided. The information was just filed recently, so Mr. Gillespie is going to get discovery to defense counsel.
Right.
And if he could request, because it will be longer than 15 minutes, maybe the 2 o'clock docket on
Fine.
June 8th.
That would, so I can fully hear what each one of y'all are going to say. But we got a special prosecutor and apparently some unusual circumstances. And it's a short delay, and here's an ICE hold anyway. So continue to June 8th at what, 2 o'clock? 2 o'clock. Thank you. Here's your paperwork back, or
Thank you, Your Honor.
maybe I brought it with me. I don't know.
Thank you, Your Honor.
Thank you. All right, what was it, Harper?
John Schoffner, 23
Schoffner?
CF 420. Your Honor, good morning. Ryan Hardy on behalf of John Schoffner, 23 CF 420. At this time, Mr. Schoffner is going to enter a plea of no contest to lesser included misdemeanor battery.
All right. Mr. Schoffner, would you please raise your right hand and be sworn? You swear the testimony you give for this course is true, so help you God.
Yes, sir.
This is 23 CF 420. You want to enter a no contest plea to a lesser included offense of misdemeanor battery, a no contest plea to that charge, correct, sir?
Yes, sir.
All right. Did you read and sign this plea and sentencing agreement form, which explains your rights that you're waiving? And you are aware of the rights you're waiving by entering this plea? Anyone force you or threaten you to enter this plea? You under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Hardy's done on your case for you?
I am.
Court finds the plea is freely and voluntarily entered. Court accepts it, adjudicates guilty of a misdemeanor battery, sentences to credit for time served, $687 court costs, $50 cost of prosecution, pay within 90 days or go to judgment. How about that? I guess you're getting out today.
Yes,
Any
sir.
objection to getting out today? All right, thank you.
Thank you, Your Honor. That's all I have.
Cornell?
And I do have a plea form, if I may approach.
Yes. Thank you.
Yes, sir.
All right, you're David Cornell. Would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God. You want to enter you are charged with violation of probation, possession of ammunition by a convicted felon, looks like a second-degree felony, under 22 CF 2224, and possession of paraphernalia, a first-degree misdemeanor, and then 23 CF 529, possession of a controlled substance, third-degree felony, possession of paraphernalia, first-degree misdemeanor, and driving license suspended or revoked, second-degree misdemeanor. And you want to enter a plea as follows. In 21 CF 376, you want to admit you violated probation and reinstate probation with community control sanctions for the remainder of supervision. And in 22 CF 2224, the state is apparently going to dismiss count 1. That's the second-degree felony. And you're going to enter a plea to count 2, looks like a first-degree misdemeanor. And in 23 CF 529, you're going to enter a no contest plea to all counts, all 3 counts, a third-degree felony, first-degree misdemeanor, and a second-degree misdemeanor. So you understand that's what you're pleading to? Did you read and sign this plea and sentencing agreement form? And you understand your rights are waiving by entering this plea? Anyone force you or threaten you to enter this plea? You under the influence of any drugs or medication that prevents you from knowing what you're doing here today? You happy with the work Ms. Dudley's done on your case for you? You happy with the work Ms. Dudley's done on your case for you? Court finds the plea is freely and voluntarily entered. Court accepts it. The court in 21 CF 376 is going to reinstate probation with community control sanctions for remainder of supervision, complete original requirements. In this case, will run coterminous with 23 CF 529. In 22 CF 2224, the state is going to dismiss count 1, and the court is going to judge you guilty on count 2 and sentence you to $270 court cost, time served, cost to be paid during supervision in 23 CF 529. In 23 CF 529, the court is going to judge you guilty on all counts, 18 months community control, $515 court costs, no drugs, random UAs. This case will run coterminous to 21 CF 376. Time served on all the misdemeanors, and I judge you guilty on the 21 CF 376, 22 CF 2224, 23 CF 529, and the state is announcing dismissal of count 1 and 22 CF 2224.
That is correct, Your Honor.
Okay.
The score sheet, I have prepared them. I need to get it from next door. For the record, he scores 40.6 points total.
All right. Is this a downward departure?
No, 40 points. He doesn't score a
Okay.
presumptive minimum.
I got you. Okay, thank you. All right, thank you, sir.
And Your Honor, his cause of supervision was originally waived. We requested for rain waived.
All right.
Okay.
Next, Ms. Dudley.
Tremaine Drake.
Yes, thank you.
Now, Mr. Drake is here in 23 CF 297, 21 CF 2140, and 21 CF 1370 for a motion to set bond. He is currently charged with violation of probation in the 2021 cases and has the no bond, and he's charged with multiple counts in 23 CF 297 and has been held with no bond on that as well. Mr. Drake is asking for a bond be set in the new charges as well as a bond on a violation of probation. I believe at first appearance they qualified him as a violent felony offense of special concern, but I didn't see any qualifying offenses as any violent crimes on his score sheet or what he's on probation for that would qualify him for that. He's not a flight risk. I didn't see any prior failure to appear convictions when I looked up his record. He's asking that a reasonable bond be set with any condition the court deems appropriate.
Ms. Leon?
Your Honor, this defendant was on probation on 2 different cases for fleeing and eluding. They were second-degree felonies. As he was on probation for those second-degree felonies, he was arrested for trafficking in several different types of drugs. Currently, he's facing trafficking in fentanyl, first-degree felony, level 9, trafficking in amphetamine or methamphetamine, trafficking in phenethylamines, trafficking in oxycodone, sell, manufacture, deliver controlled substance, 2 counts, possession of firearm by convicted felon, 2 counts, and possession of controlled substance. This defendant scores a minimum guidelines of 256 months in prison. And they're first-degree felonies. What's the main concern that the state has is the danger to the community in the distribution of those very dangerous drugs, such as especially fentanyl.
The court agrees. I'm going to leave the bond revoked and no bond on the new cases.
Thank you. I think those cases are set for the 26th.
Correct.
Yes.
Yeah, that's all I
Thank you.
have.
Thank you. Thank you, Ms. Dudley. Okay. All right. Okay. All right, Mr. Velazquez, go ahead.
And Your Honor, if I may have just a moment to go over the plea agreement that he had requested a draw up.
All right.
Come on. Your Honor, we've reached an agreement in this matter, if I may approach.
Mr. Velazquez, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God?
Yes, sir.
All right, this is 2023 CF 910, State versus Brian Velazquez. All right, Mr. Velazquez, you are charged with burglary of an occupied dwelling, criminal mischief, resisting without violence, exposure of sexual organs, a second-degree felony, a second-degree misdemeanor, and 2 first-degree misdemeanors. Third-degree felony, burglary of a structure, and the misdemeanor counts, straight up, correct?
Yes, Your Honor.
All right. Mr. Velazquez, did you read and sign this plea and sentencing form agreement which explains your rights? Are you aware of the rights you're waiving by entering this no contest plea? Okay. Are you happy with the work Ms. Rivers has done on your case for you?
She's good, very, very good.
All right. Are you under the influence of any drugs or medication that would prevent you from knowing what you're doing here today? Has anyone forced you or threatened you to enter this no contest plea? Court finds the plea is freely and voluntarily entered. Court accepts it. Count 1, burglary of a structure. You are sentenced to 2 years community control, $415 court costs, $100 cost of prosecution, $150 PD fee. You may do community service for your court costs, have a substance abuse evaluation, complete recommended counseling, schedule the evaluation within 30 days, no contact with a person named Megan Rennie, and no trespassing at 564 East Robinson Avenue, Crestview, Florida. Maintain gainful employment or complete 8 hours community service per week. Waive cost of supervision. And on the misdemeanors, you are sentenced to
Credit time served. Your
credit for time served. So you've done your time in jail on those misdemeanors. All right?
And Your Honor, I did speak with probation beforehand. There might be a possible issue in being able to do 8 hours of community service a week.
For a burglary, Judge, it's kind of tough for us to find him somewhere.
Find him work.
Find him community service work.
Your Honor, the state said that they would agree to waive that condition.
All right, so your state's, is that right? The state's agreeing to waive the 8 hours community service work per week? Yes?
Yes, I'm waiving it, Your Honor.
Okay, all right. Yeah,
Yes.
adjudicated guilty on everything.
And Your Honor, would you be waiving the supervision fees?
Yeah. Okay. Is that an arraignment docket?
It is, Judge.
Okay.
I'm so caught by surprise.
Amanda Howard, charged with possessing controlled substance without a prescription. This looks like a third-degree felony. Ms. Howard, let me tell you some rights you have. You have right to remain silent, the right to know the charges against you, the right to an attorney. If you can't afford one, would you like the court to appoint an attorney to represent you?
Yes, sir.
Where are you working?
Right now, I'm not employed.
Or to appoint public defender?
Judge, it'll be assigned to me. Jay Williams, I'll enter a plea of not guilty on her behalf. Demand trial by jury. Request 15 days for any pre-arraignment motions.
Mr. William, Your Honor, if I may announce the offer that I have,
Okay.
she may want to consider it
All right.
and save the PD fees. The offer would be for plea to a lesser included offense, possession of paraphernalia for an adjudication of guilt and court costs.
All right, the state's offering you a charge of, if you want to plead, it's, I guess, a reduced charge to a misdemeanor. Possession of paraphernalia, adjudicate you guilty, and just pay court costs. And no probation or anything?
No, no probation, Your Honor. You can pay within 90 days the court costs.
You want to do that?
The judge, essentially, we're holding off on appointing me because, so the state can make you aware of this offer. It would save you roughly $150 in terms of PD application fees and case resolution fees. If you don't want to take it, you don't have to. The court will then appoint me. We'll meet in the office. We'll talk about the offer. We'll talk about the case. I'll file a demand for discovery. I'll review it with you. And then I'll go over the plea offer with you.
I think that
some more. But
offer's
if you
just
want to
for now,
resolve it
isn't it?
today, you can resolve it today on your own. It was, what, just court costs and a
Just
lesser?
court costs.
It would, what she's saying is a
Misdemeanor.
plea to the lesser offense of possession of paraphernalia. That could be the baggie that it was in, that could be a smoking device, it could be anything used to package, utilize the substance, anything like that. That's a first-degree misdemeanor. It's a maximum of a year in county jail, and a $1,000 fine. That's not what she's asking for, and that's not what the judge would sentence you to. The judge would sentence you to court costs on it.
Yes,
Yes.
I'll take that.
You want to enter a no contest plea to that?
Yes, sir.
All right. Would you raise your right hand to be sworn? You swear the testimony you give for this court is,
Motion.
I think that's your left hand. Raise your other
Sorry.
right hand. You swear the testimony you give for this court is the truth, so help you God?
Yes, sir.
All right, this is 2023 CF 891. You want to enter a no contest plea to a misdemeanor possession of paraphernalia, which is a misdemeanor, and you'd be adjudged guilty and sentenced to pay standard court costs, and you have 90 days to do it. And so that's what you want to do, correct? Enter a no contest plea to that?
Yes, sir.
Okay. Has anyone forced you or threatened you to enter this plea?
No, sir.
You have the right to an attorney and a right to remain silent, and you're aware of all your rights you're waiving by entering this plea, correct?
Yes, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Do you feel you've been threatened or forced in any way to enter this plea?
No, sir.
All right. The court finds the plea is freely and voluntarily entered. The court accepts it. And that's a plea to a misdemeanor, possession of paraphernalia, judged guilty. You are to pay standard court costs, and you have 90 days to do it. Otherwise, it would go to a judgment.
Yes, sir.
Okay?
Thank you.
Thank you.
Office to make up a payment
All right, thank you.
Okay.
Your Honor, if I may readdress Mr. Brian Velazquez.
Okay.
Your Honor, the intent was for Mr. Velazquez to transfer to the state of Louisiana. Probation is saying that since it is community control, Louisiana will not take him. Based on that information, it does change our position. We would like to withdraw our plea at this time. Because he is homeless, he has no ability to do the community control. And probation knows him, and they've also indicated as well he has no ability for success with that current sentence. The state did give a second option, which is something that he was interested in, which was, as a second choice, which was to do some inpatient treatment. I am trying to see if Teen Challenge will accept him. Because of his priors, he can't get into places like Keaton or Phoenix House. So he would like to withdraw his plea for today. We'd like to put it on the docket for next week, and I'd just like to be able to confirm that he is going to be able to get into Teen Challenge. It wouldn't be a community control sentence then. It would just be that he had to complete their inpatient treatment.
Your Honor, I just conferred with probation, and if he's leaving Florida, I'll be agreeable to change the community control to regular probation.
You want to do that?
Your Honor, I think we can do that. pretty easily. I did speak with his mother today. She called me on the phone this morning and said that she would be willing to allow him to come live with her in Louisiana. That would be a reason for transfer. He would have to pay the $100 before we can process the paperwork, and he would have to remain in Florida until such time Louisiana accepts him. But one of the conditions of accepting him is having a stable residence in the state of Louisiana. His mother, I assume that was his mother, she portrayed herself to be his mother on the telephone this morning, said that she was willing to let him live with her.
Your Honor, he is willing to take it if the state makes that modification, because he does want to leave the area. He does want to go to Louisiana. He has a job prospect.
Mr. Velazquez, is that what you want to, actually, the state has offered you regular probation that you can serve in Louisiana. You going to live with your mom?
Yes, sir. Yes.
You want to do that?
Yes, sir. I got a good job.
Okay, I'll amend the sentence to change that community control to just regular probation that can be transferred to the state of Louisiana.
Thank you, Your Honor.
Okay?
Thank you. Thank you, Your Honor.
Does that need to be on the paperwork, Bryce? Okay. All right, good luck to you. Thank you.
Thank you.
May I approach with the score sheet for Ms. Dudley's case earlier?
Okay.
Mr. Cornell.
Okay.
Number 25, Adam Parkinson.
25.
Yes. Is he here? Okay.
All right.
And Your Honor, Mr. Parkinson is on the afternoon docket. We are requesting a continuance in this matter. If we could put him on for the end of the month, end of June.
He's on the 1:30 and 2 o'clock.
And Your Honor, Mr. Parkinson is my case, and the state has no objection.
Is that, so is he here for an arraignment?
Your Honor, he has two cases. He has violation of probation. He has a new law case. On the new law case, we would tender a not guilty plea, request that the court give us time for any pretrial motions, and then request a trial by jury. Actually, if we could put both cases on the same docket, so whatever date he would be scheduled for on the new law.
Have you been appointed? You need to be appointed on the new case, or?
I've already been appointed to the new law.
All right. What was the state?
Pretrial is 6/26, Your Honor.
All right, so we'll set we'll combine his cases and set it on June 26 pretrial. How about that?
Thank you, Your Honor.
Okay, thank you.
I'm out there for this morning, so I'll have to send them back out this afternoon.
Number 13, Capoletti.
All right. All right, you are Robert Capoletti, sir?
Yes.
Okay.
Your Honor, I'm asking to be appointed on the VOP. I think that's appropriate. I'm appointed in his new law case, 23 CF 907.
All right, I'll appoint you on the new case, 23 CF 509.
Thank you, Your Honor. And we'll ask to enter a denial and continue. We're in negotiations with the state.
All right, what you want a continuance to June 8th, you think, or is that not enough time?
Let's try for June 8th, yeah.
June 8th, okay. Thank you.
William Taylor.
Yes, Your Honor. Jennifer Flowers with RCC. For the record, for William Benjamin Taylor and 20 CF 1695 and 21 CF 1055. we'd like to enter a denial and, for purposes of today and continue it.
What
Set for
about
an-
June 29th?
That sounds good.
Is that good with the state?
Yes, Your Honor.
Okay, June 29th. Thank you.
Okay.
Of course, everything. Walk. All right, Lisa Ann Walker.
Believe she's in a wheelchair, Your Honor. So she'll-
Okay.
And,
All
Your
right.
Honor, this is Lisa Ann Walker, in 22 CF 618. We're here on a motion for a bond hearing to reinstate bond. I filed a motion with the court, and I don't know if you've had the chance to review it, but this, Ms. Walker was arrested on March 7th and was given a signature bond in this case. While out on bond, she was rearrested, and two new felony matters, and so the bond in this case was revoked. We're asking to reinstate her prior bond. In this case, she is currently in hospice care and on a breathing machine. She has a terminal cancer diagnosis and is in a lot of pain and suffering at the jail due to the lack of required medical attention. Her family has expressed that they're afraid that she just may be very uncomfortable in the jail. So we're asking for a bond to be reinstated in this case. She has a residence, she's lived locally, she's not a flight risk, and I don't believe she does have a failure to appear in this case, but it's because she was arrested that very morning, so I'm sure that the state won't be filing on that. I don't think she has any other prior failures to appear.
All right, Ms. Listen, what do you
Okay.
say? State.
Your Honor, we're objecting just due to the nature of what she's doing. She's admitted to officers on 3 different occasions that she's selling fentanyl and methamphetamine, and she was busted with 16 grams of fentanyl, 13 grams of meth in one case. She's got 23 grams and 2 grams of fentanyl. There's 3 separate incidences. It's only 2 cases, but I consolidated one of the cases into this. So she's really 3 different incidents that she's selling the fentanyl from her public housing where she lives, and she's facing a 7-year min-man, another 3-year min-man, and another 3-year min-man. So the state's concerned is that I guess she thinks she has nothing to lose, but the state's concerned that she's going to kill someone with the amount of fentanyl she's trafficking in. So,
She's in a wheelchair. She's been diagnosed with terminal cancer. Is that what you said? She's on hospice care.
Yes, Your Honor. She just made me aware that she's not going to be living in the housing that she was living in. She's going to be living with her son, who is actually present, she says, in the courtroom. I haven't spoken to him yet, but she just informed me that she's going to be living with her son now.
And she's going to be living with you, sir? Come on up for just a second.
Could you state your name for the record?
It's Robert Pennington.
Okay.
And this is your mother, is that right?
Yes.
And if I let her out on reinstate her bond, she gonna stay with you? Is that what I've been led to believe?
I was going to temporarily lodge her until we could get her into a care facility away from public housing or anything else.
Is she not gonna be in public housing?
No, I can't, obviously.
She gonna stay with you till you get her into a facility?
Yes.
I'll reinstate the bond. Okay? All right, thank you.
Thank you.
Thank you, Your Honor.
We'll have to do that on a separate date.
Miss Flowers, you have other cases?
Not on the docket today?
She is on the docket today. I didn't know she didn't know who her lawyer was, and I looked in the wrong spot.
Oh, that's
So
okay.
she was here. She's at the clerk's office right now.
I have Alyssa Trimble, Your Honor, who is apparently out of custody. I thought she was in custody. She's out of custody, and she was here.
Judge, she just asked me if she was, Jay Williams, she just asked me if she was on the docket today. I asked her who her lawyer was. I thought she was unrepresented. I looked in the wrong spot on the docket. She's actually Ms. Flowers' client. I sent her to the clerk's office. So if maybe somebody could tell her to send her back up here, I'll get her back up in front of the court as soon as she gets back.
But I also,
Unless you feel like you can handle it.
What is she
I'd like to
supposed to
meet
be
her.
here for?
just, I think it's just a violation of probation. We'd be entering a denial, but I would, if we could get her back up here, I'd like to get contact information.
Okay.
The 26th pre-trial.
26th of June. All right, what we'll do is we'll set, what date would Ms. Trimble be set for?
Did you guys?
You want to talk about that one then?
Yes, Miss Lunn was set on for a status call date. I received a letter from Florida State Hospital stating that she needs continued treatment for competency. So I guess we would ask to set that out another 6 months for a status call date.
All right, what about November 30th, something like that?
Sounds good.
How about that? Where's she at on the docket?
Are you Miss Trimble?
Okay, you Miss Trimble? All right.
Yes, this is Ms. Trimble, Jennifer Flowers with RCC on her behalf. We'd like to enter a denial today and set for the next miscellaneous date. Maybe not.
What about June 29th?
June 29th, that works for the state?
June 29th, okay.
Okay, all right.
Okay, I believe that's all I have on today's docket.
Thank you.
He's not here, right? No. He's, yes, Your Honor, he's actually Lucas Walker Davison in 22 CF 1733. He's actually in the Department of Corrections. He was sentenced in April from a Bay County case. He's not set to be released until December, so, but I guess I'm going to have to do a transport order to try to get him up here to
All right,
resolve this.
if you do a transport order, we can get him, we'll set him for, would June 29th be enough time?
I'll make an effort. I'll get it done.
What about July 6th? Want to try that instead?
I'm trying to think if I'm going to, yeah, that's fine. That's
All
good.
right, July 6th.
Gives us a little more time. Thank you, Your Honor.
Thank you. Next. Anybody else? Why are you looking at me like that? You got a case? All right, you want to,
Judge, I can call some cases.
all right.
Got it, mate?
Mr. Williams.
She's got it.
Judge, Albro Harris.
Okay.
Mason, you're at bat. Judge, Mr. Harris's case is going to be plea. It was set for call today. Mr. Harris resides in Montgomery.
All right.
If I can inquire briefly of probation, this is going to be an 1129 administrative probation. Do I need the judge to specifically order that he can write in? Madam Prosecutor, do you have any objection to him mailing in his report since this is an admin probation?
No, I know.
Okay.
All right, Alderon, is that how you say your name, sir?
Eldrion.
Aldrion, thank
Yes, sir.
you. Harris, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, sir.
Judge, there will be no score. Plea to misdemeanor.
All right, you're charged with carrying concealed firearms, a third-degree felony, and no valid driver's license, a second-degree misdemeanor, and you want to plead no contest to a misdemeanor, improper display of a firearm, a lesser-included offense, count 1, and also plead straight up to no valid driver's license as charged, a second-degree misdemeanor. So you want to enter a no contest plea to those charges as I just announced, correct?
Yes, sir.
And did you read and sign this plea and sentencing agreement, which explains what your rights are and that you're waiving these rights?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you happy with the work Mr. Williams has done on your case for you?
Yes, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 1.
It'd be 11 months, 29 days mail-in, or 29 days administrative probation, mail-in reports. He resides out of state, Judge. This will keep him from having to be under the interstate compact.
All right, on count 1, adjudication is withheld. 1129, administrative probation. Standard misdemeanor cost, $50 cost of prosecution, $50 PD app fee, $50 PD fee. And you can mail in your probationary reports. I guess you can live in is it Alabama, Montgomery, Alabama?
Yes,
Is that
sir.
what it said? Okay. And count 2, adjudication is withheld, 6 months administrative probation concurrent with count 1. Okay?
Thank you, Judge.
Anything else?
No, Your Honor.
Okay. All right.
Danny Mason. Judge, Mr. Mason has 2 cases. He advised me this morning that he's hiring private counsel, apparently a relative of his is a local
Okay.
defense attorney. He's on the docket for the, or should be on the docket for 626. These are both new law one's a PTI fail-out, the other one's a new law violation, but they would both be on the set to track each other on the regular jury trial docket. I'd suggest the court just leave him on for 626, and his...
Okay, well, what does the state say?
We can leave him on for then, but Mr. Mason, any counsel that's hired needs to be aware that the state will be ready for trial. These are old cases.
Okay, you going to get you another attorney, Mr.
Yes, sir.
Mason? Okay. Do you happen to know who that is at this time?
Dixie Powell.
Okay. All right, well, we'll set him for 626.
Thank you, Judge.
Thank you, sir.
Thank you, sir.
Thank you.
Judge, everybody else I have is incarcerated.
Your Honor, Tim,
Jennifer Albro. Okay.
Your Honor, Tim Gibbs on behalf of Jennifer Albro. This is 21 CF 2514. Judge, I think this morning we'd like to enter a plea to or an admission to the bench and proceed to sentencing this morning if the court's prepared to do so. She currently has a new violation of probation for 2 new misdemeanor cases. Judge, they're still pending. I believe she has a resolution on those that needs to be processed. Based on the score sheet that the state provided, she scores 19.05 month. I believe the plea for this morning would also include a 24-month DOC cap. Judge, she has actually been accepted into the Teen Challenge Program. We do have a letter of acceptance of that program that I'm happy to provide a copy to the court. I don't have a printed copy, unfortunately, but I do have a digital copy. She's had a history of drug problems, Judge. I don't think that she's actually had an inpatient treatment option before, and that's essentially what we're asking judges to put her back on supervision so she can enter the Teen Challenge Program. I believe the program is 1 year, followed by up to another year of aftercare and other services provided by the program.
So is this is a VOP I have, correct?
It is a violation of probation, Judge.
What does the state say about this?
Your Honor, the state has agreed to a cap of 2 years in DOC. The state believes, based on the violation of probation report, I see that back in 2016, she did do a residential treatment for at least from 61 days to 1 year, and that was unsuccessful. The history of this defendant shows violence. She has a second-degree felonies in her prior record, burglary of unoccupied dwellings, grand theft of firearms. She scores 23.25 months with the violation of probation
Can I see that
points.
score sheet, because that's different than the score sheet I received before. The score sheet I had before was 19.05 months.
How long has she been in jail on this VOP?
She's been in jail for a little over 2 months, or around 2 months now on this violation, Judge. And I have actually received from Teen Challenge, they do have 2 beds that they've actually made available, one for Ms. Albro and one for another client. They are willing to take her. She may have to transport herself to that program. I'm not sure if Teen Challenge, they're in Pensacola, I'm not sure if they do a bars to bed situation. But I have had clients that have gone there successfully, and I do know that they are wanting to accept her and wanting to enter her into the program.
Well, first on the score sheet.
Sounds like y'all still have a lot to
You
talk
have
about.
this one that shows 19, but that doesn't have the VOP points.
Oh, okay.
So when you add the VOP points, it's 23, so it's basically, I'm asking for guideline sentence.
Okay.
She's had many chances, Your Honor, and obviously she's not learning, and she's causing additional problems. Probation is recommending incarceration, and I would add that if she was sent to DOC, that the judge make a recommendation that in DOC she receives drug treatment, and they do offer that.
So y'all wanting me to just decide?
Essentially, Judge, that's kind of why we're here. The state's wanting the incarceration with a cap of 24 months. Ms. Albro has been accepted into Teen Challenge. The state mentioned earlier about she had previously gone to a residential program in 2016, and Judge, that was 7 years ago. And yes, Ms. Albro does have some violent crimes in her history. Most of that does revolve around drugs. One of the biggest issues with drug addiction, Judge, is that relapse is part of recovery, and we have an opportunity to get her into a program that is residential, that understands that understands and will help her get off of those drugs, beat that addiction, become a productive member of society. I think she does also want to address the court if I could have you swear her in, Judge.
Sort of inclined to give her about 14 months DOC credit for time served. But if she wants to talk to me, or y'all want to do other negotiations or something, but.
Well, Your Honor, this would be a downward departure. It needs to be stated in writing, the reason why the court is making a downward departure. It cannot be due to a substance abuse problem. It has to have another reason. And the defense hasn't provided any grounds for this court.
I thought that you were agreeing to some sentence anywhere from what they're asking for to 24 months.
Well,
Left up to the court.
No. Well, I agreed to a cap to 24 months.
so
She
what
scored
you're
23.6.
What you're asking is
I'm asking guidelines,
maximum guidelines or
minimum guidelines.
23?
23.6.
we'll continue this case to June, June 26th. And that's a trial, pre-trial conference. We'll go to trial or
This is a VOP, Your Honor, it's
This
not
is
a...
a VOP. We could put it the 29th.
29th. And if y'all can get it resolved, we'll bring it back sooner. And if not, we'll have a VOP hearing, and then I can just do what I need to do.
Well, Your Honor, if I may, she admitted to the violation. The sentencing is left, so I don't
When did she
understand why we're
admit?
postponing it.
I'd ask to withdraw that
When did
admission
she
from state
admit?
judge.
When did she admit to violation?
Right before, when we started, he admitted and he was pleading up to the bench, and now he's...
I don't remember her saying a word.
For the record, Judge, if there was an admission on the record, we'd withdraw that admission today.
I mean, I don't remember, did I put her under oath and take testimony from her? I don't believe I did. I believe Mr. Gibbs just started talking and.
I guess what I'm asking is the
Did I-
purpose
did
of
I-
continuing
did I put-
it.
Did I put her under oath and take any testimony from her? This is Miss Albro.
Correct, Judge. And it sounds like on the court's own motion, you want to continue this to June 29th.
Yeah, I mean, it sounds to me like y'all are still in the midst. I don't want to be involved in your negotiations.
Your Honor, there is
I
no...
thought you had
And-
sort of a,
I think to make the record more clear, Judge, the negotiation was that Ms. Leone had offered for Ms. Albro to plead to the bench with a cap of 24 months. At that time, my understanding was that she scored 19.05 months
it
presumptive
seems like there
prison.
was some confusion here as to what actually the score sheet was, what she was admitting.
I'll be agreeable to the 19 months if that was your understanding, but that would be it. And I don't see a reason for continuing it since...
We may have to just go ahead and set it with subpoenas then.
Well, y'all see if you can work it out. I'm not trying to force you to, I mean, I don't want to be involved in your plea negotiations. I thought that, my understanding was there was some kind of, it was just left up to me somewhere between nothing and 24 months. And I kind of listened to what y'all said and made a decision. And, but obviously there's some difference in opinion on the score sheet and, what the situation is, so, we'll just, and y'all tell me if I'm wrong, but I don't remember asking Miss Albro anything.
You did not, Judge. Ms. Albro doesn't have any statement on the record this morning.
So we'll just set her for, was it the 29th of June?
Correct, Judge.
Yes, thank you.
And for the record, the cap of 24 is not there anymore, so...
All right. We'll see. Your Honor, Tim Gibbs on behalf of James Alford. This is 23 CF 193. Judge, we're still working on trying to resolve this case. I'd like to go ahead and put him on pretrial 626 without subpoenas, of course, or at least at this time. It's a new law violation.
June 26th, is that what you're at?
June 26th, Judge,
What does the
yes.
state say on that?
That's fine, Your Honor.
Okay, thank you.
Judge, the next on my list is David Amerman. He's currently in the state hospital. Judge, that's 19 CF 1998, and if I'm not mistaken, I was actually his attorney when he was initially found not competent to proceed. This is essentially a status hearing on his competency. I have not received anything indicating that he is now competent to proceed. I'd like to simply continue the matter for another status hearing for at least 6 months, and we can come back and return and determine if we need to bring him back.
That's fine, Your Honor.
All
No
right,
objection.
I think that's appropriate on this case. What about November 30th? Is that okay?
That's acceptable. That works, Judge.
Okay. November 30th.
Your Honor, Tim Gibbs on behalf of Lynn Banks. This is 22 CF 2873. We have an agreement, if I may approach.
All right, this is 22 CF 2873, Lynn Edward Banks. Sir, would you please, you are Mr. Banks?
Yes,
Would
sir.
you please raise your right hand to be sworn? You swear the testimony you give for us, of course, the truth, so help you God.
So, yes, sir.
All right, you are charged with possession of a controlled substance, a third degree felony, violation of driver license restriction, HTO, a third degree felony, and possession of paraphernalia, first degree misdemeanor. And you want to change your plea to a nolo contendere plea to charge of possession of you. It looks like he's pleading straight up to these charges, correct?
If I can,
Is that,
Judge, it should be that he's got, I believe, the felony count at be for 3 years probation.
I know, but I'm saying he's pleading to the felonies, right?
Yes, Judge.
I mean, they're not reduced to
No,
misdemeanor. Okay,
they're
I
not
got
reduced,
you.
I'm sorry.
So in count 1 and 2, you're pleading up to those felonies, and also to count 3, the misdemeanor, you're pleading no contest to those charges. You understand that?
Yes, sir.
Did you read and sign this plea and sentencing form, which explains your rights that you're waiving?
Sir.
And you understand that, your rights you're waiving?
Sir.
Okay. And are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
You happy with the work Mr. Gibbs has done on your case for you?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Count 1 and 2, you're sentenced to 3 years probation. Concurrent, $100 cost of prosecution, $550 court costs, $150 PD fee. Substance abuse evaluation and treatment. You're adjudicated on both those counts. Count 3, you're sentenced to, on the misdemeanor, to time served. You're adjudicated on guilty on that also. And apparently the state is not going to take any action on a failure to appear charge.
That is correct, Your Honor.
All right. Anything further on Mr. Banks?
Not that I have, Judge.
Thank you.
Your Honor, due to him being declared indigent, we request the supervision fees be waived.
All right, granted.
Ms. Cook's score sheet. It is a downward departure. Are you going to print for the score sheet, Judge? That is a downward departure.
All right.
Based on, plea bargain.
Amber
Judge Tim,
Barrow.
yes, Your Honor,
Okay.
thank you. Tim Gibbs on behalf of Amber Barrow. This is 22 CF 2602. Judge, we'd like to set this for June 8th without subpoenas. I think by then we'll have all the necessary referrals in for an inpatient treatment for Ms. Barrow.
Anything from the state?
No objection.
June 8th.
Thank you. Your Honor, Tim Gibbs on behalf of Ryan Bielick. This is 21 CF 403, 21 CF 876. This is a violation of probation on these counts, on these case numbers, Judge. We have an agreement if I may approach.
All right. Mr. Bielick, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God.
Yes, sir.
All right. This is case number 21 CF 403, 21 CF 876. And Mr. Bielick, you want to admit that you violated probation on those cases, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this admission of violation of probation?
Yes, sir.
Are you under the influence of any kind of medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Have you been forced or threatened in any way to enter this admission?
No, sir.
Are you happy with the work Mr. Gibbs has done on your case for you?
Yes, sir.
Court finds admission freely and voluntarily entered. Court accepts it, adjudicates you. Court's going to terminate probation, merge all outstanding requirements to a concurrent 4-year probationary term in 22 CF 1477 and 22 CF 2278, adding $200 cost of prosecution and $250 PD fee.
To make the record clear, Judge, essentially what we're doing is he's no longer on probation in these case numbers. It's just that those 2022 case numbers are absorbing the outstanding requirements. This violation of probation was essentially due to expiration. He had still owed some restitution, some costs, as well as needing to do a substance
All
abuse
right.
evaluation.
So the admission today is being absorbed into 22 CF 1477 and 22 CF 2278.
Essentially, Judge, yes.
All right. Thank you.
So you probably still need to meet with probation, okay, because you're still on probation.
And Your Honor, his previous supervision fees were waived. We request these.
All right.
be waived also.
Okay.
Your Honor, Tim Gibbs on behalf of Marcella Black. This is 20 CF 565, if I may approach with a written plea.
All right. Miss Marcella Black?
Yes,
Would
Your
you
Honor.
please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God.
Yes, Your Honor.
May I approach the score sheet?
Yes.
No objection to the score sheet, Judge.
You want to enter a, Ms. Black, you want to enter a no contest plea to the charge of possession of a controlled substance, count 1, and possession of a controlled substance, count 2, both third-degree felonies. You understand that?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form which waives your rights?
Yes, Your Honor.
Has anyone forced you or threatened you to enter this no contest plea?
No, Your Honor.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today? Has anyone, are you happy with the work Mr. Gibbs has done on your case for you?
Yes, Your Honor.
Court finds the plea is freely and voluntarily entered. Court accepts it. On both counts, you're sentenced to credit for time served, $150 court cost of prosecution, $515 court cost, $150 PD fee, $222.48 cost of transportation to the Okaloosa County Sheriff's Office, would due within 180 days. And the court's going to withhold adjudication on both counts.
Thank you, Your Honor.
The state will be taking no action on the FTA.
Thank you.
No action on the failure to appear.
Thank you very much.
Thank you, Your Honor.
Your Honor, Tim Gibbs on behalf of Wendy Boardman. This is 22 CF 1407. Judge, she's got this is a violation of probation. We had been waiting for Dr. Zeman to evaluate her for competency. That order was done back in April. I had contacted Dr. Zeman's office earlier this week. He indicated that he had not received the order from either the clerk or the court. I sent him a copy of that order. He should be able to evaluate Ms. Boardman in the middle of June. So I'd like to put her for, I believe we have July 6th as an available miscellaneous date for that morning to ensure that we have the evaluation as well as his
All right.
report.
July 6th? Okay, thank you.
Thank you, Judge. Judge, for Mr. Dillingham, he's also in the state hospital currently, Judge. This was a status conference, I believe, that was set by Judge Ketchel. I'd just like to continue this case for 6 months as well to November 30th for a status conference there as well. I have not received any reports indicating that he is competent to proceed at this time.
No objection.
All right, November 30th.
Thank you. You're just getting reorganized back there? Okay.
Y'all want to take a break for 15 minutes? Okay.
No objection either way.
Thank you for your permission. All right, John Michael Bono.
Is that how you pronounce your last name? Boujno. Your Honor, this is Mr. Boujno, 22 CF 590, 22 CF 1406. If I could have just one moment to review. this is what you want to do, I need you to sign right there, please. And today's date, please, May 25th. Thank you very much. All right, if I may approach, Judge. Score sheet included, no objection.
Mr. Boujno, would you please raise your right hand to be sworn? You swear the testimony you give for this court's the truth, so help you God?
Yes, I do.
All right, you are charged with violation of probation. You want to admit that you violated probation in 22 CF 590 and 22 CF 1406.
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done on your case for you?
Yes, sir.
Court finds the admission is freely and voluntarily entered. Court accepts it. The court's going to revoke and terminate. And probation and establish and sentence you to is that 1 or 2?
It's a new 2-year term, Judge.
New 2-year term of drug offender probation. You're to enter and complete Keaton, bars to bed, comply with Keaton policies, automatic early termination upon completion of Keaton and aftercare, $200 cost of prosecution, $250 PD fee, all money to collections, and you're adjudicated guilty on both cases.
And we're asking all the money that he owes on probation currently as well goes to collections.
All right. Court orders that.
Thank you, Judge.
Thank you.
I can send you a copy, yeah. Here, Mr. Boujno, you probably need to go meet with probation.
Crash-landed that one. Okay.
Yes.
Your Honor, on the news now, we request the supervision fees be waived because it's going to keep.
All right.
Thank you. Got to keep me on my toes with that, Barry. I keep forgetting.
It's Mr. Boulabo.
Your Honor,
Okay.
this is Mr. Michael Bullaboy, 21 CF 2621, 21 CF 2633. He's currently on your 2 o'clock docket, Judge. We've asked to bring him this morning. I had filed a motion to continue. We're still trying to get some records on his case before we proceed to an evidentiary hearing, so we're asking for a continuance to, I believe, June 29th should be sufficient.
Any objection? All right. June 29th, thank you.
Very well, thank you. We'll try to get all that done. Mhm. Your Honor, Tim Gibbs on behalf of Hunter Carmichael. This is 23 CF 585. Your Honor, we're here for a bond motion this morning, motion to reduce or modify bond.
Okay, Hunter Glenn Carmichael.
Yes, Judge.
Right, okay. All right. Bond hearing, I guess. Go
Yes,
ahead.
Judge. Thank you. Judge, he's been in jail since March 7th, currently has a total bond of $120,000 cash or professional. That's so excessive as tantamount as to precluding him from being able to furnish it. Judge, he's requesting a reduction to $5,000 on each of the counts for which he's facing. That would bring it to a total of $20,000 cash or professional. He would also be amenable to pretrial supervision. I know that there is an alleged victim in this case, so of course, no contact with that person would be a necessary requirement. Judge, he has lived in the area for over 10 years. He would be residing in Holt. His mother is on disability. He would be needing to take care of her. She has a limited income through Social Security. He only has an 8th grade level of education, Judge. I don't believe that he's ever failed to appear for court. There's no reason to believe that he would skip town or he would not come to court if he was given a lower bond that he could actually make. And we're actually, I know the state's working on getting us discovery. I just haven't received it yet. But we'll naturally be going through and trying to fight these charges. He is wanting to take care of these charges as quickly as possible. And I have no reason to believe that he won't come to court again. That is the point of a bond, is to ensure his appearance in court.
Your Honor, the state believes the bond is appropriate in this case. I want to refer the court's attention especially to, I'm sorry, the mental health evaluation that defendant underwent.
The only reason I'd object to that is because it is supposed to be confidential, but
I'm
otherwise-
only addressing that to the extent that there is information about the victim and a statement that the victim made to pretrial services that he fears for his life. And he knows, he was aware that the defendant was threatening some retaliation if he were released. The victim identified the defendant, the victim knows the defendant. The defendant shot at the victim as the victim was passing by with his car, and the bullet hit the back of the car. And based on the location of the bullet, it's understandable that he intended to shoot at the driver of the car, which was the victim. He wasn't arrested at the time of the shooting, which happened in January 28, 2023. There was an arrest warrant that it was going to be served on the defendant on March 7, 2023. Very differently from any other case that I have prosecuted in the past, the deputy who made the arrest, who was serving the arrest warrant on March 7, actually wrote a statement, a letter to the court, stating the following, and that's part of the court record. The defendant, Hunter Carmichael, fled from law enforcement during today's warrant service that led to a multi-hour, multi-agency canine search. Hunter told his mother he was not going back to jail and would perform suicide by cop before being apprehended, which he relayed to law enforcement. A complainant advised he observed Hunter with a weapon on today's date, and there is a recent prior complaint of Hunter shooting into an occupied vehicle with a firearm. With the totality of the circumstances, I ask you to please take this into consideration while calculating his bond, as it could be a threat to the safety to the public. That's exactly what the state believes, and that's the reason why the state believes that the bond, as it is set right now, it's appropriate. He's facing a maximum of 35 years in prison. The author is incarceration for a minimum of 5 years, followed by probation. The state requests that defendant's motion be denied.
I'm gonna leave the bond the way it is, especially with that suicide by a cop threat, so, all right, thank you.
Thank you.
Understood. He should already be set for the June 26th for pretrial.
All right, thank you. Frederick Lee Crothers, all right.
Your Honor, Tim Gibbs on behalf of Mr. Carruthers. This is 22 CF 3038, 23 CF 755, 23 CF 798. Judge, we're here for a motion to set, reduce, or modify bond in all three of these cases. He's been in the jail most recently since March 30th. Currently, his bond in 22 CF 3038 has been revoked due to the allegations in the two new law cases, the other two new cases, 23 CF 755, 23 CF 798. We're asking that his bond be reinstated in 22 CF 3038. In 23 CF 755, Judge, he currently has a $10,000 cash professional bond. He is unable to provide any bond money at this time. He currently is trying to start a new job. He's trying to start two new part-time jobs. And hasn't really gotten a lot of money yet from those to be able to furnish his payments, to be able to furnish a bond even to a bondsman. So he's requesting an ROR signature bond on those matters. Of course, pretrial supervision being, he's being amenable to that. The similar on 23 CF 798, he currently has a total bond of $5,000 cash professional. We're asking that be modified to ROR signature as well due to the sense that he is completely unable to post any sort of cash or professional bond in these cases. Judge, he has moved down here recently. He's been here for over a year. He is trying to he's been recently employed with Burger King and Pick and Save. He was about to start his employment there, but he has since been arrested on these new charges. They do include burglary with assault or a battery, We're working on getting defense witnesses on those cases, as well as on the 2022 case, Judge. Our understanding is that he's charged with aggravated assault with a deadly weapon, as well as possession of firearm by a convicted felon. The allegations in that case include that they were searching for a firearm that was allegedly hidden behind a series of trees for over an hour, trying to find this firearm, that only one person is able to say that Mr. Crothers had in his possession, that we're not quite sure if that person's even going to be available for testimony or even a deposition. We have depositions set. We're waiting on service for that. He does have a GED. He's got trade certificates in welding, modern carpentry, custodial maintenance. I don't believe he's ever failed to appear to court, and I don't believe that he would miss court if he's required to do so if he was given bonds that he's able to meet.
State objects to defendant's motion because, as defense stated, he was out on bond on charges of aggravated assault by threat with a deadly weapon, and that was a handgun. And obviously, carrying concealed firearm by convicted felon, that charge carries a minimum mandatory of 3 years. As he was out on bond on that case in March, and he picked that up December 3rd, 2022. 3 months later, a little over 4 months later, he committed a burglary with assault and battery. That has a maximum punishment of life in prison. And the same day, hours later, he committed the same, another burglary against 2 different victims. All 3 cases, Your Honor, have 3 different victims. In a prior record shows violence. He was convicted of aggravated assault by threat with a deadly weapon.
Is that in Florida?
The score sheet doesn't reflect that. Okay. And possession of firearm by convicted felon. I'm not sure if it's in Florida or not. It's in its prior record. Right now, this scores a minimum of 102 months in prison, and a maximum of life. He violated.
I'm gonna leave the bonds the way they are.
Okay, thank you, Your Honor.
Minimum possible, minimum mandatories. It's a flight risk, so I'm going to leave the bonds the way they are.
He should also already be on 626, I believe, for pretrial. And I don't know if he's been arraigned. No, he has been arraigned on the 2 new charges. On the 20, he has been arraigned on the 2 new charges, Judge.
All right, thank you.
You should have filed it today. So, but we'll do it. We'll have pretrial on 626. Change your bonds, and so you don't have to be.
Jasmine Lee Cobb, okay?
Your Honor, Tim Gibbs on behalf of Jasmine Cobb. This is 23 CF 106, violation of probation. We have reached an agreement, if I may approach.
Yes. Mr. Cobb, would you please raise your right hand to be sworn? You swear the testimony you give before this court's the truth, so help you God?
Yes, sir.
Okay. In case number 23 CF 106, State versus Jasmine Lee Cobb, you want to admit that you violated probation. Is that correct, sir?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which explains your rights that you're waiving?
Do you remember signing that?
Oh, yes, sir.
Anyone force you or threaten you to sign this agreement? Anyone force you or threaten you
No,
to sign
no, sir.
this? Are you under any medication or drugs that would prevent you from knowing what you're
No,
doing?
sir.
Are you happy with the work Mr. Gibbs has done on your case for you today?
Yes, sir.
Court finds the admission to violation of probation is freely and voluntarily entered. The court accepts it. The court's going to revoke and terminate probation. Sentence you to 6 months Okaloosa County Jail, credit for time served, $100 cost of prosecution, $150 PD fee. All monetary requirements due within 180 days of release before being sent to collections, and you're adjudicated guilty.
Thank you, Judge.
Thank you, Your Honor.
Thank you.
Your Honor, Tim Gibbs on behalf of Justin English.
Okay.
This is 21 CF 2151, 22 CF 3185, 23 CF 739, if I can have just one moment. Is that what you want to do? That's what you want to do. I need you to sign right there, please.
Mr. English, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
Thank you.
And write today's date, 5/25. Thank you. If I may approach, Your Honor.
All right.
Apologies in advance for the atrocious handwriting.
Okay. All right, this is 21 CF 2151, violation of probation. 22 CF 3185, violation of probation. And 23 CF 739, felony battery, a third-degree felony, and resisting arrest with, is it without
violence,
without
Judge.
violence, a first-degree misdemeanor. And Mr. English, you want to enter a admission to the violation of probation on the 21 CF 2151 and the 22 CF 3185, and on the 23 CF 739, enter a plea to a lesser included offense of battery, a misdemeanor on count 1, and count 2, resisting arrest without violence, a misdemeanor also. You want to, that's what you want to do. You understand all that?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which explains your rights that you're waiving?
Yes, sir.
Do you want to force you or threaten you to enter this admission and plea?
No.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir.
Court finds the admission and the plea is freely and voluntarily entered. Court accepts it. On 21 CF 2151, the court's going to reinstate probation to the original terms and conditions, remainder on community control, $100 cost of prosecution, $150 PD fee. The terms may transfer to later probation.
So the three cases are probably going to each have their own termination dates, Judge. The idea being that if one terminates before another, any outstanding monetary requirements can be transferred to the next termination
All right,
date.
so it gives him extra time
Yes,
to
Judge.
pay? Is that what you're doing? All right, in 22 CF 3185, this court's going to reinstate the original terms of probation concurrent with 21 CF 2151, $100 cost of prosecution, $150 PD fee. The terms may transfer to the later probation in case 23 CF 739, count 1. And count 2, the court is going to sentence you to concurrent 11.29 months probation concurrent, $50 cost of prosecution, $627 court cost, $50 PD fee, no violent contact with Desiree Lige? Okay. And was this adjudicated on all these, did I say?
I believe he was still had a withhold on the possession, the felony, Judge. I didn't clear that up with the state if we could still withhold. So we'll leave that to the discretion of the court.
Anybody, any
No, he violated probation. I'll ask for an adjudication.
adjudication on everything?
Very well.
All right. All right, anything further for Mr. English?
Not that I have, Judge.
Okay, thank you, sir.
On this, other cases, the supervision fees were waived. We request the supervision fees be waived on the new
All right.
23 case.
I don't even remember. Mr. Gibbs?
These are the score sheets for a case closed.
Just get squashed.
Y'all want to keep going through lunch, or do you want to take a lunch break?
Go on.
Pardon?
We're gonna have to come at the 1:30 anyway.
Did y'all say keep going?
People set for 1:30.
I think we don't have that many more. We've been making good progress.
And will you help me ask him for this? Let me see what he's wanted.
Yeah, for now, yeah.
I've only got a handful more. I don't know how much Mr. Rivers and Mr. Williams have. So it's up to them.
I'd rather just keep on going instead of
Yes, that's fine.
taking a break. Okay. This is Kip Carlton Fee.
Yes, Your Honor. Tim Gibbs on
Okay.
behalf of Mr. Fee, 21 CF 189, 21 CF 1475. These are both violations of community control, Judge. We have received an offer from the state. I've been speaking with Mr. Fee. We've also tried to get him referred to some inpatient treatment as well as a potential option. I'm not sure if the state's going to agree to that. He's indicating today that he wants to try to resolve these cases today, these violations today. That's against my advice. I'm trying to still negotiate with the state. I'm trying to get those referrals out, but he wants to essentially put himself at the mercy of the court today. I believe he would score close to, I don't think he scores presumptive. I think he scores very close to being presumptive. So it would be a pure discretionary sentence on the court if the court was willing to sentence him today. But again, as I mentioned, that was him pleading up to the bench today is against my advice as we try to see if we can resolve this otherwise.
May I speak?
Hang on one second. What does the state say?
The state's concern is that it's fourth VOP, so obviously supervision doesn't work with Mr. Fee. The only option is incarceration. I don't know how much credit he has between the cases.
I do, but
The credit he has.
if we're doing sentencing today, the judge is not allowed to know per case law, so I'm not going to say that right now.
Oh,
Yeah.
I know that.
I don't know if the court wants to sentence him yet or not, so.
Well,
Oh,
so he's got two cases, both violation of community control, correct?
Correct.
And what type of sentence is he looking at?
So the last recommendation, last offer we got from, I'm sorry, I'm muted myself. The last offer we got from the state judge was essentially 12-1 DOC. I think the score sheet that was provided showed him as scoring about 44 points. It was like 43 and some change, so he doesn't score presumptive as of yet. I know Mr. Fee would be requesting the court to put him back on community control with a suspended sentence. Otherwise, we were going to be looking into inpatient options, and I know the state's recommendation, of course, is at the very least is that 12-1 DOC.
and you're on a 12-1 DOC. I recommended DOC instead of jail because obviously he has a drug problem and DOC can offer that treatment. He hasn't done any of the conditions that he ever had. So placing him again on community control would be a waste of time and resources for everybody. I'll be agreeable to 1129 in jail. As I said, I wanted DOC for the treatment.
What does he want to do? Plead or go to hearing?
Judge, he still wants to enter an admission today.
All right, Mr. Fee, would you raise your right hand to be sworn? You swear the testimony you give for us court's the truth, so help you God.
Yes, sir.
You want to admit that you violated community control in case number 2021 CF 189 and 2021 CF 1475. Is that correct?
In hopes of a suspended sentence, yes, Your Honor.
Wait, what?
I said in hopes of a suspended sentence, yes, Your Honor.
In what? No. You don't put conditions on the court
Okay.
like that.
I apologize.
Well, I'm not angry at you for it. I'm just telling you, you don't enter a conditional plea. You either admit that you want to violate, that you violated probation, or you want to go to deny and go to a hearing. What you want to do? You want to admit?
If you admit it, the sentence is completely up to him. We can only just ask for what we ask for and make our recommendations. If you admit, the judge is going to determine what he thinks is the most appropriate sentence. That includes up to the maximum. So he could sentence you to prison, he could give you a suspended sentence. It's completely up to what he thinks is appropriate.
I'll go ahead and admit.
Okay.
All right. So you want to admit you violated community control on 2021 CF 189 and 2021 CF 1475, correct? Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
I am.
Do you have any questions about the rights you're waiving by entering this admission?
No, sir.
You understand that court can give you state prison time?
Is that a yes?
Yes, sir.
Court finds the admission is freely and voluntarily entered. Court accepts it, adjudicates you guilty, sentence you to 11 months, 29 days, county jail concurrent on both cases. Credit for time served.
About that much. That's going to be up to the jail. The jail will calculate that. They'll send a letter. If you think that that amount is wrong, let me know, and I can look into it.
Okay, so I have about 257 days in.
That was my estimate. It's not necessarily right, but it's my estimate.
Okay, and you'll be in touch?
If you think that's an incorrect amount, when the jail calculates it, let me know. I can look into it.
So ask them to calculate it.
The jail will calculate it later today. Yes, sir.
And Your Honor, the outstanding money to collections and probation is revoked, is that correct?
Yes, probation revoked and outstanding money to collections.
Thank you.
Court sheet, Mr. Gibbs, you mind?
Yeah. I've seen it, so I don't have an objection. Thank you. Your Honor, Tim Gibbs on behalf of Heather Gary. This is 23 CF 717. She was set this morning for an early plea or change of plea. This is a new law violation. We'd ask if we can approach Judge with a written.
Ms. Gary, would you raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
All right, you want to enter a no contest plea to count 2, possession of paraphernalia, a misdemeanor, and the state's going to drop the charges on count 1, possession of a controlled substance. You understand that?
Yes, sir.
You want to enter a no contest plea to that count, that charge, possession of paraphernalia?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which explains your rights that you're waiving by entering this plea?
Yes, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, sir, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. On count 2, possession of paraphernalia, misdemeanor, court's going to sentence you to 45 days, Okaloosa County Jail, credit for time served, $50 cost of prosecution, $220 court costs, $100 PD fee, money due within 180 days of release before being sent to collections. You're adjudicated, and the state apparently is going to null pros count 1.
That is correct, Your Honor.
All right.
Thank you, Judge.
Anything further?
Not that I have.
Thank you.
Good luck. You should be close. So they're going to calculate it. Okay. Yeah. We don't need a swear sheet.
No, but it's the kid.
Oh,
kid.
All right, this is Jeffrey Gunter.
This is for Mr. Fee, Judge.
Oh, okay.
Your Honor, Tim Gibbs on behalf of Jeffrey Gunter. This is 21 CF 800. Judge, it's a violation of probation. We have reached an agreement with the state, if I may approach with a written plea.
All right. Mr. Gunter, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Sir.
Thank you.
No objection to the score sheet, Judge. It is a downward departure for a legitimate, uncoerced bargain. So we just wanted to make sure that was clear on the record.
All right. right, Mr. Gunter, you are here on a violation of probation, and you want to enter an admission to violating the probation, is that correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Did.
Do you understand the rights you're waiving by entering this admission?
Yes, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you happy with the work Mr. Gibbs has done on your case for you?
Sir.
Court finds the admission freely and voluntarily entered. Court accepts it. Court adjudicates you guilty, reinstates probation to original terms and conditions, adding $100 cost of prosecution, $150 PD fee, a GPS monitor, no more than $1 per day, must be fitted prior to release, $135.49 cost of transportation to Okaloosa County Sheriff's Office, substance abuse evaluation treatment, and random UAs. And adjudicated. Anything further?
We'd ask that the supervision fees be waived, Judge.
Waived.
Thank you, Judge.
Thank you, sir. Speak.
So meet with them, and you'll be good to go. Thank you, Judge.
Julius Sledge. Okay.
Yes, Your Honor, that's 22 CF 2218. Your Honor, Mr. Sledge previously had fired me in court, and then when he was rearrested, Judge Ward reappointed me. I asked him yesterday if he had requested me. He did not. He did ask me to check on a couple of things for him. That was, first of all, he is accused of failing to appear in court, and I guess a warrant was issued for him. He was sitting in the county jail at the time of that court date. I did ask court security to have that ready to verify too.
Well, let me ask you, are you wanting to be reappointed?
No, Your Honor, he is going to hire Mr. Tony.
Well, you're representing him, though.
Well, she might as well handle the case here.
Okay.
It wasn't number 2 years.
Hang on one second. Don't say nothing, because I don't want you to mess up your case.
Okay.
What?
Your Honor, he did not want me. He fired me. He told the court he was getting Jeff Tony.
Mr. Tony?
But then Judge Ward appointed me to represent him
Is that
without asking him.
at first appearance?
Yes, Your Honor.
On this case?
Yes, Your Honor.
Well, it was actually also on his new arrest
But
case,
on
right?
his new arrest, it doesn't list, it lists his no attorney.
You want to,
Was that the same day?
Mr. Sledge, do you want me to appoint the public defender to represent you? And at some point in time, if you hire Mr. Tony, then he can file an appearance?
Yes, sir. We'll go with this because may I say something?
Well, hang on one second. You want me to appoint the public
Yes, sir.
defender? Ms. Rivers, okay. It's not her as a public defender, but I can't choose who represents you in their office. You can't either. They just assign them, right?
Yes, sir.
Okay, I'll appoint the public defender on his case.
And Your Honor, the other thing, he had indicated concern, his family had concern about a previous case where I had represented him for an appeal. I did look that up. The clerk's office has entered new data and indicated that the case is open. The case is not open. He was sentenced on a VOP to a prison sentence. He served the prison sentence. The last entry before the May one indicated comments about court cost and what to do with the court cost. But there's nothing that can be done on that case. Your family shouldn't worry. That case is done.
That's why I said I want to hire somebody.
What do we want to do? What are we on in this case? 22 CF 2218.
Okay, you want to take her off her? or
Yeah,
what?
I wanted to take the offer. I just didn't know if it was going to send me back to prison the first time because it said an appeal. That's why I said
Yes,
that.
and that's, yeah.
Okay.
Offer is what?
Your Honor, the offer on this case is 24 months of probation. There's restitution, no trespassing at the scene, no contact with the victim, drug evaluation and treatment, and no possession of drugs or alcohol without a prescription.
Raise your right hand to be sworn. Mr. Sledge, you swear the testimony you give for is course the truth, so help you God.
Yes, sir.
You want to enter, do we have a plea form or a score
Yeah, we
sheet
can
or
do-
something?
I can do one.
Mr. Williams, do you have a case that we could do while,
I do, Judge. I have 3 cases left.
well, hang on a second. Why don't we just take, let's just take a 15-minute break.
Okay.
And then you can talk to Mr. Sledge, get that paperwork, and then we'll take just a 15-minute break, okay?
All right. All rise, please. Yep. If we could, that'd be good.
What are you agreeing to?
Yeah, thank you.
Is that lunch?
Look over here working on other stuff. We knew that's what we'd be doing today.
Didn't she work for somebody or something like that?
I want to tell you that I think she's the owner of Sophie's Nails.
Oh. Is she?
Yeah, really?
No,
No, thank you.
I'm good, thank you.
So how many years?
You know why? The one time, because
That's right, I think I told you.
You told me to go there. I went there twice, and this time I didn't see her. The second time, what struck me about her
Was a criminal mischief misdemeanor?
But you saw the eyes.
But I saw the eyes, right?
Yeah, it's
And from the eyes, what?
greater than
blue eyes?
200, less
Yeah,
than
she had like, she had like.
That's what I
she had-
charged
She had
her
darker hair,
as.
yeah, she had black hair.
But the restitution is more than that.
No, no, she looks more regular.
Right,
So what do you want to do on the misdemeanors?
she's fluid, I mean.
So can you just put?
Yeah, because she was telling us that, yeah, she spoke, I mean, when they lived in Yemen, or they spoke Vietnamese.
Yeah, I mean, right, but I'm.
Oh, misdemeanor.
And then, see
Remember
what
that?
she first came in.
Judge, no.
She
No,
spelled
in
her
the
name
States,
S-A-T-H-I-A.
I thought it was S-H-F-I-A-H.
It's not Sophia, not the law.
It's Safi.
Right?
Don't look at it.
But when she was she said Sophia. Well, I go by Sophie.
Sophie.
And that related to the nail. Sophie's nail.
Maybe, yeah, if
I
you've
think
seen
she's
her
the owner, and I've seen her there.
Maybe.
That works for me.
Actually,
it was having a good run.
Getting nasty down there.
Get ready to do the information on this one, and I can do, finish the discovery, and then I can.
Get the shaver. Make some Parmesan cheese.
We're down to that one.
Now that I'm hungry, I guess.
You're not anymore.
Right, I guess that helps, you know, like, okay.
Yeah, I guess if Miss Albro still wants to try.
Canada or whatever, right?
I'll have to restructure
Not
it.
forward, I used to. Not with you, but why you continuing? Give me something.
I don't know what Craig Albro has. I don't even know.
What's the vina? Is it probation?
Well, it's the new misdemeanors. With Gloria Pettit, you know, she got into a fight with Gloria Pettit.
Oh,
I
that one
know
that
her.
is the.
I remember that name.
Uh-huh.
But you remember her?
She's also, Gloria's also the alleged victim on one of Carruthers cases that happened.
I know, and she's
I
violent,
thought-
Sarah,
No,
the
she
petty
just
lawyer.
has, she has a lot of horrible friends. And she likes
Oh,
to-
she's a thief, so she's a liar.
I like that, she has a lot of horrible friends.
Yeah, that's what she's got a lot of horrible friends.
I like that. I used to tell my juveniles, you need new friends. You just keep getting arrested with them.
They're not your friends.
I mean,
I especially told my inmate friends, it's like, you see these people in here? They're not your friends.
you know, I used to tell my juveniles, either get new friends or stop committing crimes with your friends, because then you get all these co-defendants too.
That's always the fun
By
part.
yourself.
That's always the fun part about juvenile, though, is, yeah, all the co-defendants, and then they get one case, they have 7. Like, it just happens overnight. It's just like, all right, we're here for a detention hearing on, you know, Mr. So-and-so for a burglary of a conveyance.
And
then the next,
like 20 of them.
and then the next day, you have a detention hearing for 6 more.
Yeah. And then they start hitting all the same cars in the same day.
No, it's not. They're hearing us. They just sent me a text message. You didn't mute the thing. So
It
the
always
TV.
forgets to. We have the crazy defense.
Oh, we have crazy defendant?
My crazy defendant, Rivera.
You have a contested?
Oh, no, it's
Questions asked,
Oh, I know.
They could hear it, they couldn't see it, but they could hear it. So that's how they always got ideas, like.
Or old Joe.
Charge him for such.
He ain't, he's not aggravating or anything. He just
I moved it up there.
Because someone heard someone.
.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boys Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestview.agent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
From Thomas Main Street Ice Cream, inviting you to come down and get yourself a banana split, shakes, malts, and we're only a block south of the courthouse. And we have too many flavors to even start mentioning, so come on down and take a look.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Hi, I'm Amanda Gaskin with Briar Patch Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
Black-owned bakery cafe is 2 blocks from the courthouse on Crestview's historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Bad Boy's Juicy Beef and Tasty Bird is located at 482 North Wilston Street in historic downtown Crestview, just 1 block from the courthouse. We open at 10 a.m. with amazing lunch specials until 2 p.m., serving incredible burgers, wings, sandwiches, and appetizers. Join us for happy hour Monday through Friday from 3 p.m. to 6 p.m. Hope to see you soon.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
Congratulations, Dixie Dan Powell, for your recent induction into the National Trial Lawyers Top 100. The National Trial Lawyers Top 100 is an organization celebrating premier trial lawyers from across the country who meet stringent qualifications as civil and/or criminal defense lawyers.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
For more than 70 years, the sweet aroma of the Crestview's Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045. Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
All right, you want to enter a no contest plea to the charge of
Possession of controlled substance, criminal mischief.
okay, I got you. So he's pleading to the charges as charged, correct? Okay, you want to enter a plea of no contest to count 1, possession of controlled substance, count 2, that's a 3rd-degree felony, count 2, criminal mischief, first-degree misdemeanor, and count 3, possession of paraphernalia, first-degree misdemeanor, and this is 22 CF 2218. Did you read and sign this plea and sentencing agreement sheet, Mr. Sledge?
Sir.
Are you aware of the rights you're waiving by entering this plea?
Sir.
Anyone force you or threaten you to enter this plea?
Sir.
You under the influence of any medication or drugs that would prevent you from knowing what you're doing here today? You happy with the work Ms. Rivers done on your case for you?
Sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Sentence you to 2 years probation on count 1. 1 year concurrent probation on the misdemeanors with a substance count 2 and 3. Have a substance abuse evaluation and complete any recommended treatment. No trespassing at the scene of the crime.
I'll write it down at the bottom, Your Honor.
At 2905 Schoffner Avenue, Crestview, Florida. $1,563.40 to Tanya Miles. Is that right? No alcohol or drugs without a prescription. Waive cost of supervision, $515 court cost, $100 cost of prosecution, $150 PD fee, adjudicated on all counts, guilty. And I guess he's getting out. Is he getting out today?
Well, Your Honor, he did want to address that failure to appear where he was in.
For this case, he was in jail for the FTA, so the state would be taking no action on that.
Okay, no.
It does affect his ability to bond out.
All right, no action on that, so I guess you'll be getting out today. Okay, thank you.
That's number 40 on my docket, Judge.
Okay.
Your Honor, we've reached an agreement in this matter, if I may approach.
Yes. Sorry about that. Are you Anita Smith?
Yes, ma'am.
Would
Sir.
you? All right. Would you raise your right hand and be sworn? You swear the testimony you give for is course the truth, so help you God?
Help me God.
You want to enter an admission to violation of probation? Did you read and sign this plea and sentencing agreement form, which explains your rights that you're waiving? You do?
Yes, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, I'm not.
Has anyone forced you or threatened you to enter this admission?
No, they haven't.
Are you happy with the work Ms. Rivers has done on your case for you?
Yes, I am.
Court finds the admission freely and voluntarily entered. Court accepts it. Judge guilty. Sentence you to credit for time served, $100 cost of prosecution, $150 PD fee, revoke and terminate probation, and that's it.
Thank
Sure.
you, sir. Thank you. Good luck. I want to hug you, but I can't. Thank you.
I'm sorry, that outstanding DOT monies to collections.
Yes.
Please.
Your Honor, if I may have just a moment with Ms.
Okay.
All right. Just need to sign it right there. Okay. We've reached an agreement in this matter, if I may approach, Your Honor.
All right. Mr. Taylor, would you raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
All right. You want to enter a no contest plea in 22 CF 1262, 23 CF 670, 23 CF 670 count 2, and 23 671 count 1. And those are charges of grand theft, a third-degree felony, burglary of an unoccupied conveyance, a third-degree felony, criminal mischief, a third-degree felony, and grand theft again, a third-degree felony. And the state is going to take no action on 22 CF 1262. That is the failure to appear. So you understand what you are entering a plea to?
Yes, sir.
Those charges?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which explains your rights you're waiving?
Yes, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
You happy with the work Ms. Rivers has done on your case for
Absolutely,
you?
sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Judge you guilty in all cases, all counts. Since the 2 years community control followed by 2 years probation, is that a concurrent sentence on each case?
Yes, Your
Each
Honor.
count? Okay. Substance abuse evaluation, complete any recommended treatment. Random drug testing, 1 AA or NA per week for the first 6 months. Do not return to Project Hope or 2810 Rickberg Lane, Crestview, Florida. $500 in restitution to Donald Williams in 22 CF 1262. Reserve on restitution to Matthew Moore in 23 CF 671. $1,145 in restitution to Raul Morales in 23 CF 670. $415 on court costs times 3, $100 cost of prosecution times 3, $100 PD fee times 3, $50 PD application fee, and waive cost of supervision, and adjudicated on all counts, all cases.
And Your Honor, there also should be a no return to 3201 Heritage Plantation Boulevard in Laurel Hill. Is that on there?
No, but no return to that address in Laurel Hill, Florida.
Yes, sir.
Okay?
Good luck.
Good. Thank you.
Thank you.
Oh, may I approach for this first?
I was going to say, I think I'm...
This is a unforced legitimate.
Hello there.
All right.
Good. You ready?
Yes, ma'am.
Your Honor, we've reached an agreement in this matter, if I may approach.
Yes. Is this James
Patrick Smith.
Patrick Smith? Let's see. Oh, Patrick Sean Smith?
Yes, Your Honor.
Okay, good. What, reached agreement?
Yes,
Oh,
Your Honor.
I got you. Okay, I'm sorry. Mr. Smith, would you raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
All right, this is 23 CF 705 and 23 CF 439. You want to enter a no contest plea to in 23 CF 705, a felony, possession of a controlled substance, a third-degree felony, and in 23 CF 705, count 2, a misdemeanor, possession of drug equipment, and in 23 CF 439, possession of controlled substance, a third-degree felony, and 23 CF 439, count 2, possession of drug equipment, a misdemeanor, first degree. So you want to enter a no contest plea to those charges, correct, sir?
Yes, sir.
And you read and sign this plea and sentencing agreement form, which explains your rights that you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done on your case for you?
Yes, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. On sentence you to, is it time served on both the misdemeanors in both cases?
Yes, Your Honor.
Is that what that is? Okay. Sentence you to time served on both misdemeanor cases, counts in both cases. On the felony cases, the felony counts on both cases, you're judged guilty, 5 years probation. You're judged guilty on those misdemeanors too. But on the felonies, judged guilty, 5 years probation, Keaton bars to bed, cannot leave Keaton without permission for the first 6 months after release. You must attend one AA or one NA meeting per week, random UAs. You're not to possess or consume without prescription any type of drugs. If you're charged with a VOP, any out-of-county witness can appear by Zoom with a notary. $515 court cost times 2, $100 cost of prosecution times 2, $100 PD fee times 2, $50 application fee one time, and waive cost of supervision. Did I get that all right for Mr. Smith?
Yes, sir.
Okay, thank you.
May I approach with a score sheet, Your Honor?
Yeah.
Thank you, Ms. Rivers.
Your Honor, I believe that's 42 on my docket.
All right, Mr. Tedder?
Yes, sir.
Okay.
And Your Honor, he actually has 2 cases. We're asking to resolve both of them. So that's 23 CF 983 and 23 CF 358.
Okay. Yes. Mr. Tedder, would you please raise your right hand to be sworn? You swear the testimony you give for this court is true, so help you God?
Yes, sir.
All right, this is 23 CF 983 and 23 CF 358. You want to enter a guilty plea to the charge of possession of a controlled substance, a third-degree felony in the 358, and possession of a controlled substance, a third-degree felony in 983, and in 983, a charge of possession of drug equipment, a first-degree misdemeanor. Is that what you want to do here today, sir?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which explains your rights you're waiving?
Yes, sir.
Did anyone force you, threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done
Yes, sir.
on your case? And then some reason this paragraph 13 is highlighted on the,
Yes, Your Honor, since it is a drug case, I always try to emphasize that to make sure that
right, so you understand this is going to have an effect on your driver's license. You
Yes, sir.
understand that, sir?
Yes, sir.
Okay. Court finds the plea is freely and voluntarily entered. Court accepts it. You're judged guilty on both cases and the counts. You're sentenced to credit for time served on both cases, both counts. $515 cost of court cost times 2, $100 cost of prosecution times 2, $100 PD fee times 2, $50 PD application one time. Adjudicated guilty on all counts, all cases.
Your Honor, that was 30 days jail on all cases.
Oh, I thought it was, oh, I'm sorry. You judge guilty, sentenced to 30 days county jail, credit for time served on all cases. Okay.
You ready? You never did sign it.
Yes.
Okay.
Can I correct that at the end?
Your Honor, we were unable to reach an agreement in this case. Mr. Truder would like to tender a plea straight up to the court. And I do have the signed copy saying that it would be a plea straight up.
Ms. Rivers, ma'am, do you have a copy of the score sheet?
I don't have it with me, but
I didn't know. Judge Gonterak, Your Honor, would the court wish the score sheet now or at the time of sentencing?
Well, I mean, have it now, I guess.
I have it right here, ma'am. Show it to you real quickly. I've shown it to Ms. Rivers and
All right, is he charged with a,
single count of failure to register, Your Honor?
that is 22 CF 1430 failure, excuse me, let me start again. 22 CF 1121 failure of a sex offender to register a temporary address.
That's correct.
And that's a third-degree felony, 5 years, right?
Yes, Your Honor.
And then the 22 CF 1430, what is that a?
It's a fugitive from justice. It doesn't have a penalty designation, and normally the state withdraws that charge once they tender a plea.
Is that what the
And the state would do so, Your
And
Honor.
waive extradition, which he's previously waived extradition.
The state
Okay.
would do so, Your Honor, as to the fugitive from justice charge.
All right, so you want to enter a no contest plea to this third-degree felony, failure of a sex offender to register a temporary address. That's a third-degree felony, 5 years, 5-year felony. You understand that?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing?
No, sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, I am. I'm blessed. For
Court
her.
finds the plea is freely and voluntarily entered. Court accepts it. Adjudicates you guilty, and your score sheet is, well, we got 28.2 months is the lowest permissible prison sentence in months, and the maximum is 5 years. Y'all want to argue what you want on each side? Okay. All right, go ahead. Ms. Basso.
Your Honor, excuse me, based on his failure to register as a sexual offender and his prior history of failing to register in Michigan, criminal mischief, unlawful sexual acts with a minor, and DUI, the state is asking for an adjudication of guilt and 36 months in the Department of Corrections, and we're not asking for any probation to follow.
All right.
I do not believe there is any valid basis for a downward departure, Your Honor.
And what does the defense say?
Your Honor, Mr. Truder has previously served, while waiting to come to court, 13 months in the Okaloosa County Jail. I did speak with him the other day about the fact that there's a corpus issue in this case, and he still wanted to go forward with his no contest plea. The only reason he is standing here today is because he said to the officer, he was honest with the officer, and said that he had spent more than 2 nights in the state of Florida. The state has absolutely no evidence to substantiate that. It's based on his admission. He's trying to do the right thing. He does feel like that 13 months is enough. He does have a hold now in another state, and he is asking for the court to impose time served, let him go to the other state, or in the alternative, to sentence him to some probation. And I do believe he did want to say a couple of things to the court.
All right. Mr. Truder, would you raise your right hand to be, I guess I did swear you already. Go ahead. What do you want to say?
I've been here 13 months as of tomorrow for a nonviolent charge. I here for registration. There's no victim, there's no property damage. I was traveling to Florida from my home state of Alabama, where I was registered, going back and forth looking for a summer job in the Navarre area and the Destin area. I don't have a violent history, a violent past. I have 1 felony on my record, and it's from this particular situation, which happened in 2005. I don't pose a threat to the community. I've been cleared by doctors, therapists, and counselors, and I wasn't here on any malicious intent. I was simply just looking for work, and I was crossing state lines from where I'm from, where I'm registered in Alabama, going back and forth from Alabama to Florida, and I'm not labeled a predator to the state.
So he was properly registered in Alabama and
Yes, sir.
drove over here looking for a job?
Yes, sir.
What do you sound?
In the Navarre, Destin area, because of work here in the summertime is busy, and it's a good area. It's a red area. I love this area, and where I'm from in Alabama, it's way out in the boonies, and it's hard living. And like I said, I wasn't coming here looking for trouble or any malicious intent. I was going back and forth, just looking for a summer job here.
Say this corpus delicti. In other words, they had no evidence against him except for his own statement.
Correct, Your Honor.
What does the state say?
Your Honor, first of all, he has been a sex offender since 2007 and is well aware of the requirements of how they're supposed to register within 48 hours of being in a state. He does have a prior failure to register in Michigan. Additionally, Your Honor, if the court wishes, I do have a copy of the Fugitive from Justice report that Ms. Rivers referred to earlier, and it basically said that the defendant is a wanted person out of Coffee County, Alabama for the offense of failure to register as a sex offender. So when he says he's been registering, according to the Fugitive from Justice report that the state has, that I'm willing to share with the court, of course, Your Honor, that would be a false statement. So the state would
And we would disagree. That has occurred since he's been incarcerated, according to him.
Because I can't register in that county, Your Honor, because I've been in here for the 13 months. And the Michigan registration, it's because my grandmother had died. My grandmother gave a vehicle to my mom, and because Michigan law says I have to register that vehicle, even though I don't drive it, it's in my parents' house, and that was from 2007 or 8, whenever that was. It wasn't my vehicle, but I had to register it because it was under that roof of my parents' permission. It's my parents' vehicle, but it wasn't mine. But you have to register, whether it was a four-wheeler or a bike. Graham Home changed the law while I was getting out. I didn't know that I had to register my mom's vehicle, even though it was not my vehicle. I was not driving it.
And Your Honor, back to the corpus argument, there's no way for the state, if we were to say had a trial today, there would have been no way for them to prove that he had stayed in the state more than 2 days or 3 days. It was all based on his own testimony.
Well, he's served 13 and a half months already on this?
Yes, Your Honor, in the Okaloosa County Jail.
What are y'all asking for?
Credit time served, and let Alabama take it, because he now has a violation because he was sitting here.
And obviously, I can't register there while I've been in here.
Anything further?
Your Honor, the state would still contend that the defense does not provide a legal basis for a downward departure. We do not believe that the court is legally able to go below the guidelines in this case.
Do you have anything to say about that corpus delicti argument?
No, Your Honor. I mean, he chose to admit it. If they had wished to take it to trial, then certainly the state would have had some further investigation if we felt that was a deficit. But he chose to enter the plea, so the court should proceed based upon the fact that he admitted his guilt, and the state can establish the charges.
Any reasons for downward departure?
Your Honor, the reason being that there is in fact a deficit in the state's case. They would have been unable at trial to prove this. He has cooperated fully with the police on scene. He's cooperated every step of the way, and we believe that in the interest of justice that the court can find reasons outside of the boxes that are listed at the bottom of the score sheet as reasons for departure, and we believe that in this particular case, that the fact that he wouldn't even be here if it wasn't for him honestly speaking with the officer, that the fact that the state doesn't have a corpus argument, cannot prove corpus in this case, is a valid reason to depart.
I'm going to send you time served, downward departure. Defendant provided substantial assistance by fully cooperating in the case. The defense asserts the state had corpus delicti problems, proving case, and defendant served 13 months county jail waiting trial on this case. I'll put over state's objection.
Thank you, sir. Thank you.
Okay. All right.
And Your Honor, the fugitive from justice case is 22 CF 1430. State would announce a null pros.
All right,
Or no
thank you.
pros. I don't believe it was filed on, but the state will be taking no action on that case and will file the appropriate paperwork.
Okay. Next one. Whitman? What's the next case?
He's not in custody.
Your Honor, this was set for a status. He is in another institution. I did receive a report yesterday on him where they're saying he is still incompetent, but he has been incarcerated for 5 years. I would request, because I think the state's going to want the time, I would request that we put this on a different date and then send an order to transport him so we can have a hearing, because he has been incompetent for 5 years.
For the 29th of June.
That's fine.
You'll get me the appropriate.
Is this, are we talking about Todd Whitman?
Oh, sorry, no, sir. Samachi Todd, yes, sorry, Todd Whitman.
Okay. So that is, you wanted to go on June 29th for him?
Yes, sir.
And he's in, what, state hospital
Yes,
right
Your Honor.
now? Okay. He's been in a hospital for 5 years, I guess, you said?
Yes, Your Honor, so we will be seeking a dismissal.
How about, what's next, Jody Yawn?
Jody Yawn, Your Honor, he is, I believe, to be in the state hospital as well. We have not received any reports on him, and I would request that we put this on another court date and that we ask that they file a report.
29th.
Yeah.
June
June
29th.
29th, okay.
Your Honor, the last case I have for this morning is Terry, well, it may be the last. How about Ms. Ulrich?
Zelm?
Yes, Terry Zelm. Your Honor, something has changed since I saw her yesterday, and I need to advise her of that.
Okay.
That's all I had to tell you. Your Honor, we've reached an agreement in this matter, if I may.
All right. All right, Terry Ann Zelm, would you please raise your right hand to be sworn? You swear the testimony you give before this court is true, so help you God?
Yes, sir.
Okay. You want to admit that you violated probation in 2019 CF 2237?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which you are waiving your rights? You understand that?
Yes, sir.
Has anyone forced you or threatened you to enter this admission of violation of probation?
No, sir.
Are you under the influence of any medication or drugs that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Rivers has done on your case for you?
Yes, sir.
Court finds admission freely and voluntary enter. Court accepts it, reinstates probation, but converts remaining time to community control. All original terms and conditions are still required and imposed. Have a mental health evaluation, complete any recommended treatment, take any prescribed medications, and enroll within 30 days. have a substance abuse evaluation and complete any recommended treatment and enroll in that course within 30 days. $100 cost of prosecution, $150 PD fee, waive cost of supervision, and adjudicated guilty.
Your Honor, I did speak with probation, Mr. Berry, and with Ms. Basso, because I know that probation normally stands up at this point and says one or the other for doing it within 30 days, enrolling within 30 days, and I believe Ms. Basso.
Yes, Your Honor. If that's probation's preference that the court order it to prioritize one or the other, then the state would have no objection to that.
All right, I'll do that.
Probably gonna go with the mental health first, Your Honor.
All right, try mental health enrollment first, okay? Thank you.
Mr. Manley.
Benny Maurice Manley.
Show your arrest date there. We got the 19th shot. Okay. Do you mind if I date it for you?
Oh, that's fine.
Yeah, oh, it's 90 days county jail. Yeah, it's a DOP. No. It's a revoking term. It's just straight 90 days to resolve it. That's why everything's being sent to collections.
All right, Mr. Manley, would you please raise your right hand to be sworn? You swear the test. All right. Can you hear me?
Yes.
All right, would you raise your right hand to be sworn? You swear the testimony you give before this court's true, so help you God?
Yes.
All right, this is 20 CF 1651, a violation of probation plea. Mr. Manley, you want to admit that you violated probation?
Yes.
Did you read and sign this plea and sentencing agreement form in which you're waiving your rights?
Yes.
You understand the rights you're waiving?
Yes.
Has anyone forced you or threatened you to enter this admission to violation of probation?
Sir.
Has anyone forced you or threatened you to enter this admission? Are you under the influence of any drugs or medication that would prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done on your case for you?
Yes.
The court finds the admission is freely and voluntarily entered. The court accepts it. You're judged guilty. Since the 90 days county jail with credit for time served since the violation of probation arrest on April 6, 2023. $100 cost of prosecution, $50 PD app fee, $100 PD fee, $311.86 transportation cost to Okaloosa County Sheriff's Department. Send all financials, including remaining financials, from probation to collections. The court's going to revoke and terminate, what does that say, probation?
Revoking term probation, Judge.
Okay. And judged guilty. Anything further?
Nothing further, Your Honor.
All right, thank you.
That was Benny Manley.
Hey, come on out, Mr. Davidson.
Mr. Davidson, would you please raise your right hand to be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
Okay. You want to enter you are charged with carrying concealed firearm, a third-degree felony, and you want to enter a no contest plea to that charge. Is that correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form, which waives your rights? Do you understand that?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir, I'm not.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir, I am.
Court finds the plea is freely and voluntarily entered. Court accepts it. Withhold.
Decipher my handwriting for me?
No, I got withhold adjudication, 36 months probation.
Forfeit the firearm and no possession of weapons or firearm while on probation.
Forfeit the firearm, no possession of firearms while on probation. You're sentenced to 36 months probation and then $450 court costs, $100 cost of prosecution, $50 PD fee, $100 PD app, no, excuse me, $50 PD app fee, $100 PD fee. And what is 1 MT, 1 month?
Judge, I think that was where I was starting to write the waiver on the cost supervision. I'll just let probation.
Oh, I got you. So waive cost of supervision, is that what, okay.
Yes, sir, he's a public defender client. So.
All right. All right, did I get everything?
Your Honor, there is an FTA associated with this case, but the state will take no action on that.
All right, the state's going to drop the FTA, okay?
Okay.
So it looks like you got 36 months probation with these other things,
Yes, sir.
okay? All right, thank you.
We meet with you briefly over here. Well, sir, unless you've got something else holding you in jail, you'll be released today. I don't know if you've got a hold from another state on something like that. So I can't speak to that, but unless you have something else holding you here, you'll be released today. There's
Yes, sir.
nothing else on this case that's holding you.
Yes, sir.
Okay.
All right, next. What about Kenneth McIntosh? Is this Kenneth McIntosh?
This is Judge. Judge, Mr. McIntosh has a violation of probation. It doesn't look like we're going to be able to, or what it looks like is I'm ultimately going to have to set a hearing on this. He does have a 5-year suspended sentence, but based on my review so far and my discussions with Mr. McIntosh, it doesn't appear to me to be willful. It's also questionable whether it's substantial. So, Judge, we can go ahead and set it today. What I'd prefer to do is go ahead and reset it for another date. I'll speak with him. We've gotten a letter from an individual that was present on this occasion.
What about June 29th?
June 29th is fine with me, Judge.
State?
That's fine with the state, Your Honor, and it's my understanding that's without subs, Mr. Williams?
Uh,
Or yes or no?
If we're going to do it without subs, is there an earlier date, Judge? It's a relatively simple set of facts.
June 8th.
Did you, Ms. Basso, can you confirm that you got a reciprocal listing, Mr. Patel? Okay. Let's set it for call on that date, and that will still give us the 29th to have a contested hearing on.
So for call on the 8th, is that what you're saying? And then set
Yes.
it, okay.
Yes, sir. Or yes, ma'am.
So I believe, Your Honor, Mr. Williams is asking for the 8th without subpoenas at this time.
That's correct.
All right.
Thank you, Judge.
Okay.
I'll come back out to the jail and talk with you again. And Judge, I believe that's all the business I have before the court this morning. I have more business this afternoon.
We're already in this afternoon.
Well, I was
can't leave if that's what you're. What's next? We got arraignments. Pardon?
I believe that's the end of the morning docket, Judge.
Well, y'all want to do, don't we have arraignments at
At 1:30, Judge.
anything else y'all wanted, any other cases y'all want to do before 1:30?
I don't have anybody here until 1:30, Judge.
Why don't y'all maybe talk with the state and we can maybe take some pleas at arraignment or something?
I have a few set for arraignment with their inmates, Judge.
If mine are here, if the jail has them, I can go ahead and arraign them now. I've got one person who's out of jail, and that's Ms. Cole. I can tell you that's going to be perhaps a little interesting. Ms. Cole is noted as communicating by handwriting only on her first appearance paper.
I don't want to hear about any of that stuff now. So what do you want to come back at 1:30? Do you want to come back at, where's my gavel?
Do we have inmates here for arraignment?
I have inmates that we can take care of. Yeah. If those inmates are here, yes, let's go. I don't think those inmates are here.
All right, if they're here, let's go.
Well, who do we have? Awesome. Makes my life a lot easier. Like I said. Mr. Dufell is here. Get all my paperwork. Are you all here for arraignment as well? What's your name, sir? Angel Trewick? Okay. What's your name, sir? Have an attorney?
All right, this is 2023 CF 825, Hunter John Duffel.
Your Honor, Tim Gibbs, on behalf of Mr. Duffel, would like to enter a not guilty plea and leave this set for pretrial.
All right. He's charged with sex assault on act on certain minors, so not guilty plea, and set it for what, June?
I think he's already set for June 26th.
June 26th, okay. Not guilty, public defender's appointed. Thank you.
Who else we got? Do we not have Mr. Brumby?
Next we have Ion.
Showing no attorney. Showing no attorney, Judge.
How is this spelled?
This is Mr. Hallmark, Halmac.
Okay.
All right, sir, you are Ion Hallmark. This is 2023 CF 897. This is an arraignment. You are charged on an out-of-state fugitive from justice. You have the right to remain silent, the right to know the charges against you, which I've just told you. You have the right to an attorney. If you cannot afford an attorney, would you like me to appoint the public defender to represent you on this case? Would you like me to appoint the public defender to help you out and represent you on this case? You got to say it out loud. Yes. Is there an offer for him?
Your Honor, he's also charged in 23 CF 899 with 20-something counts of possession of stolen credit cards, things like that. I'm not sure if the court has that arraignment set for today as well.
I don't have it on a docket.
But it looks like
All right, so apparently he has an attorney already. Ms. Harris.
Ms. Harris, your attorney?
Yeah, it is.
Okay, so I won't appoint the public defender. And did she file notice of appearance on this?
Italiano? Italiano?
With the public defender's office in Escambia. Are we sure she was appearing privately as opposed to?
That's my understanding, is I believe she works privately now.
Okay, okay.
I appreciate that, thank you.
Well, I'll tell you what, let's point, we'll point the public defender on the 897, the one case,
We can get with, we can
and then
with
get
Ms.
with her and figure out if she just failed to file notice of appearance on that.
I don't believe there's been an information filed in the 23 CF 897 fugitive from justice. This is a co-defendant
Yeah.
that Mr. Gillespie, the special prosecutor for the white collar
Right.
crime, will handle. But typically, we wait to file on this when they have.
Well, let's wait, what we'll do is continue this arraignment to, when's the next arraignment date?
I think June 8th,
What about after that?
June 29th.
Let's go with June 8th and set him on that for arraignment. And then he's been pled not guilty on those other charges by, I guess, Ms. Harris, so, okay? And on that case, we'll set him for June 26th pretrial. How about that? Okay? All right, thank you.
Next, we have Andrew Karen with Mr. Williams.
Stand over by me, Mr. Herron.
All right, this is Andrew Caleb Heron.
Judge, Jay Williams for Mr. Herron. I'm going to enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions, and demand trial by jury.
All right, he's charged with grand theft or vehicle theft, not guilty plea, request for jury trial. How about June 26th pretrial?
That's fine, Judge.
All right. Thank you.
Thank you, Judge.
Okay, Mr. Harris.
Next, we have Timothy Ingram.
Anything?
Judge, this is Mr. Ingram. I'm going to enter a plea of not guilty on his behalf, request 15 days for any pre-arraignment motions, and demand trial by jury.
All right, this is 2023 CF 786. He's charged with domestic violence, battery, and obstruction of justice. So a not guilty plea. How about June 26th pretrial?
Thank you, Judge. That'll be fine.
May I just say something, Your Honor? Mr. Williams, did you have a chance to look at my offer?
Your Honor, if we can approach briefly.
All right, not guilty.
Yes, sir.
Okay, June 26th.
Thank you, Judge. Okay.
You have people in the audience that are here?
I just have one in the audience. That would be Virginia Coles. I don't see her present, Judge.
Okay.
My remaining incarcerated is Miss Linton. If you've got somebody else for Tim or Lisa, that's fine. Is here? Okay.
Here, this is from Mr. Ingram. Jay. It's his copy, so then.
Oh, okay.
Is this Timothy Ingram?
No, this is Philip Merritt, Judge.
Oh, okay, I'm sorry.
Number 24.
Okay. Philip Michael Allen Merritt.
Yes, sir.
All right. This is case number 2023 CF 941. Charged as an out-of-state fugitive from justice. Is that the only charge?
Your Honor, we haven't filed an information on the criminal justice.
You
We
have
haven't
not?
filed an information. He's got 2 pending cases here. Have you waived extradition?
No, I've been held to 30 days. Or actually, today's 31 days.
What's he charged with? What's he being held on?
This is the first I've sold. Your Honor, can we set this on May 30th?
So this is an arraignment, correct, on fugitive justice?
Correct, that's correct.
You want to set it May 30th, see about if he's being held here properly or not? Is that what
Well,
we're...
Your Honor, so the time on the FFJ doesn't start running until the local charges are resolved, because even if he waived extradition and we got the governor's warrant, we can't release him because he's got 2 pending charges with us. So the time per the statute, it doesn't start ticking until the local charges are resolved. So that's why we typically don't file on the FFJ cases, because usually we work it out with a requesting state.
All right, so you want to continue this to May 30th? Is that what you're saying?
I don't know if that would give me enough time to go off Monday.
June
Well, we have
8th.
it set for June 29th. Or June 8th.
June 8th. All right, perhaps you might be released. We'll see. Okay, continue to June 8th. Thank you.
Did I have an out of custody that's on the afternoon docket?
Duncan? Okay.
I believe he's already been arraigned on this case, Judge, in the South End. This had been transferred up by the state attorney's office to this division. We'll be looking into that. But otherwise, Judge, for Mr. Duncan's case, we were appointed when it was in the South End. We'd like to go ahead and make sure that the record's clear that he's tendered a not guilty plea.
All right, Michael Henry Duncan, is that right?
Yes, Judge.
2023 CF 912. This is arraignment, correct?
It should be an arraignment here, I guess.
It was set for arraignment today, but I believe he's already been arraigned in the South End. The state attorney's office down there transferred it up here.
All right, I guess he was plead not guilty.
We'll just leave it on the 26th, June 26th for now.
Okay.
Hold on, actually, Judge, he may change his mind. Judge, actually, I think we do actually have an agreement on the case. If I could just take a moment to write that out.
Okay.
I'll seek right now. Okay, perfect. Yeah. Do you have a
I don't have it yet. I just took it back.
All right, anyone else that we can take right now? All right, why don't we take a break to, we'll say a 20-minute break. Okay?
Yes, thank you.
All right, please.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office on North Verdon Boulevard for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients. at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery,